I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. It's good to have you here. We have 4 interesting cases and at least 8 outstanding lawyers. It's really good to be here. And Judge Richardson and I in particular want to welcome Judge Dawson to the Fourth Circuit Court of Appeals. And it's an honor to have him with us and to assist us in the handling of our work. And with that, in the first case, it's the it says Walsh versus medical staffing. I think probably there's somebody other than Walsh. It's the labor secretary now, but I don't know who it is. But anyway, it's number 22-1290. Mr. Pafford?
Yes, Your Honor. Good morning, Your Honors. Abram Pafford on behalf of Appellants Medical Staffing of America, DBA, Steadfast Medical, and Lisa Pitts. May it please the Court, this appeal is a worker classification dispute arising under the Fair Labor Standards Act involving more than 1,000 skilled nurses at dozens of medical facilities spread across multiple states over a 6-year period. All of the nurses invested in their own training, licensing, and equipment and routinely exercise proactive control over their work schedules, including on the threshold decision of whether to work at all during any given pay period. The core economic reality of Steadfast's relationship with these nursing workers is embodied in 3 propositions that we believe are not in dispute. First, Steadfast exercised almost no control over the manner in which the nurses performed their medical work. Second, per the district court's own findings, the nurses had a high degree of autonomy with respect to when, where, and under what conditions they worked, and were able to accept or decline shifts while not being held to a minimum or maximum number of hours. Third, 17 of the 20 nurses who testified at trial were asked whether
Before you get into all that detail, how do we have jurisdiction here?
We believe you have jurisdiction over the liability question that was the foundation of the district court's injunction under the portion of the statute that authorizes appellate jurisdiction over interlocutory orders that grant injunctions.
You concede as an interlocutory order.
Yes.
So we don't have jurisdiction over everything that you all have briefed at all. We don't. You claim it's an injunction, that you're appealing from the entry of an injunction, correct?
Correct. And what I would suggest...
And you're still litigating in the district court.
That's correct.
Matter of fact, you've litigated, you had a hearing a week ago today.
That's correct, Your Honor.
In the district court.
Yes.
Why is it that nobody's kept us apprised of the fact that you're litigating in the district court since you got the so-called injunction?
Certainly. The recent, perhaps we should have apprised the court of the recent developments, although I don't know that the recent developments that deal with post-trial compliance issues surrounding my client have much to do with the finality or not of the original order. And certainly in our briefs, I think...
Judge Jackson at the hearing last week said that there was a final judgment. I've looked at the transcript.
Certainly.
It's on the website or something. One of my law clerks found it. He had a hearing last Thursday, and Judge Jackson said he entered a final order. You say you're on part of that. Why do we do it piecemeal?
I think what happened here, and we have outlined this, I think, in the jurisdictional section of the opening brief, is that the January 15th, 2022 memorandum opinion from the district court made a decision with respect to liability that was the foundation for the injunction, and ultimately it went to the question of whether we had properly classified these workers or not. By the same token, that opinion, although it made some findings in relation to back pay, left more to be done, and we thought it was fairly clear under this court's initial Calderon v. Geico decision from 2014 that if you compare Calderon to what happened here, it's quite similar. And the court in Calderon made very clear that when you have these open issues on back pay, and in this case those open issues led to a flurry of post-opinion briefing in the
post-appeal briefing.
No.
Well, you had you filed the notice of appeal in March.
Correct. And shortly before...
Last year, the notice of appeal. And at one point, and you cited in your brief, I think, that the judge said he wasn't going to, there's nothing going to happen till the appeal's resolved.
Yes.
That's in your brief.
Yes, that's correct.
And
if I could sort of outline the sequence of events.
And you've had bond proceedings and contempt proceedings and discovery proceedings.
I don't know about discovery proceedings, and some of those were initiated by the Department of Labor, but look.
Well, the discovery proceeding, you had discovery proceedings, y'all can't agree on what you're supposed to turn over in connection with the trying to get to a final order.
Sure, if you're referencing the discussion last week in the district court, I was there, and...
Well, I'm sure it was not just at that hearing. There were others too, weren't there?
No,
there were no other hearings?
The only post-judgment appearance in front of the district court has been the proceeding that took place last week.
Oh, it was? So all the rest of it was just on the paper?
That's correct.
All that litigation about the bond was just on paper?
That's correct. And in fact, the bond litigation, the bond motion was preceded by other motions that we can see are still unresolved on the district court docket. What happened is if you recollect the court's January...
Well, why wouldn't we just let you all finish that case in the district court and then come up here?
I think the court...
I mean, that's what we do normally. We hear final order appeals, final decisions. Rule 1291 says we hear on final decisions. You can appeal from a final decision.
Certainly.
And the injunction says comply with the law. That's like my mother telling me to stay out of trouble when I went to college or something.
We wonder whether either are effective.
That's right.
Can I ask it maybe a slightly different way? Sure. Could you have chosen instead, the injunction has immediate effect, and that's why 1292 tells us that we have jurisdiction interlocutory over an injunction. But could you have instead chosen to wait until all of these issues were resolved and raised it as a single appeal?
The answer is that it was not clear to us whether we could, in part because there is a dispute in the district court briefing, Judge King, that you allude to. If you look at the briefing that began on March 13th of 2022, this was within the 60-day window where the court said on January 15th that it had a 60-day window where it was going to take more information, order the parties to cooperate, and it was going to look at payroll records that post-dated the last set that the court had from, I think, June of 2021, and it was going to arrive at a final back pay number.
And so you had concerns that it, in a sense, is sort of protective, right? Because some aspects of what the district court said and did suggested it was a final order, and others suggested that it was not. But there was no doubt in your mind that you could appeal the injunction based on 1292, and so that's the approach you took. And the part about the back pay, those arguments are really sort of protective, not, you don't really think we can reach those questions, right?
No, we certainly don't think you can reach the back pay question now, which is why we haven't briefed the back pay question. The district court still has probably about 100 pages of briefing on its docket on the back pay question that it has not yet ruled upon. And that's the motion that we filed on March 13th. There was a Department of Labor opposition on, I believe, the 27th, and then a reply brief on April 10th.
So can I just transition you back to the first, and I want to hear what your third point is, but on the first point, the district, you say they did not have control over the manner in which the nurses, conducted their work. And the district, and I just want you to help me understand, the district court said, no, there was extensive control because they addressed their dress code, right, and their compliance with HIPAA and their timeliness, right? And why in your view is that not like extensive control over the manner in which a nurse does their job?
I think because, number one, it has nothing to do with the core nursing tasks that they are being paid for. If you look at this court's analysis of the control factor in McFeely, in Chow, and in Schultz, the control analysis focused on the core tasks that the worker was being paid to carry out and the extent to which those were managed by or controlled by the alleged employer. Here, we think things like show up on time, don't sleep in patients' beds, wear appropriate clothing are more appropriately analogized to some of the baseline contractual expectations this court in McFeely said can properly be enforced as part of a contractual bargain. I think the other answer, and maybe the cleaner way to look at it, is simply to contrast the record in this case with the 4 healthcare registry cases from other courts that have been relied upon by the DOL. In each of those cases, you have a defendant that has in place a supervisory infrastructure that they've invested in geared specifically toward monitoring and controlling the manner in which the nurses perform their work. That infrastructure consists of requirements.
And by that, you mean the manner in which they perform their work? You mean the medical side, right? Not the like things that would apply if they were, cleaning the hospital as well, right? I mean, the dress code and don't harass people and don't sleep in a patient's bed would apply no matter what job they were doing in the hospital. If you were sending somebody into a hospital to clean it or to be a guard or to do any other job in the hospital, you'd have to do those things.
That's correct, and those would apply with equal force whether the arrangement for any of the workers you described was contractual in nature or an employer-employee relationship, right? Those baseline expectations are omnipresent in any kind of working relationship. And I think, again, if you look at the cases that they rely upon, the infrastructure these other places had included routine site visits by the defendant to the facilities where the work was being carried out. It included employment by the defendant of medical liaisons who were capable of overseeing the nursing work and providing feedback and control with relation to their medical duties. It included,
Mr. Pafford, but how do you then reconcile that with the ability to discipline? You talked about this global infrastructure, but now when you start to, in fact, breach or not do what you've been told to do, this isn't just simply don't sleep in patients' beds, but when that happens, then I can discipline you. Help me reconcile there.
Sure. I think, again, as this court has emphasized in its classification cases that we've discussed in the briefs, there are baseline contractual expectations, including those that go to performance and to the nature of the work to be carried out, that a counterparty to a contract is allowed to enforce. And the point that we make on discipline is that the issues that gave rise to discipline by Steadfast, number one, were relatively isolated against the backdrop of the volume of activity here, but number two, none of that discipline or alleged discipline by Steadfast had anything to do with the manner in which the nurses were carrying out their medical duties. Instead, it goes to some of the baseline things we discussed a moment ago, such as show up on time, if you're going to call out for a shift, please give us at least 2 hours notice, don't sleep in patients' beds, and then beyond that, the more significant discipline in the record was discipline initiated per directives from the facilities, and there's not a lot of specifics about what led to those DNR designations by the facilities, but to the extent that we do have a couple of anecdotal examples in the record, it involves, in one instance, suspicion of a nurse being under the influence while on the job, and in the other instance is suspicion that a nurse was diverting drugs, from the hospital while performing her shift.
What was the discipline that Steadfast imposed in that scenario?
In which scenario, Your Honor?
In either of them. It doesn't. Tell me both, right? So the one that was dealing drugs and the one that was drunk.
Sure. But the drunk and the drug scenarios, right? Those examples, we would say that the discipline is not actually being imposed by Steadfast.
No, but what did Steadfast do is what I'm asking.
When it received a DNR designation from the facility.
What is DNR speak?
Do not return.
Okay.
So Steadfast would make sure that nurse was not able to return to that. They just wouldn't.
So, but that's not discipline, right? What I'm trying to ask is what did so the hospital says don't send the drunk nurse back.
Yes.
All right, they don't send the drunk nurse back. That doesn't strike me as discipline, right? But what I'm asking is what did Steadfast do that was discipline? I mean, did they garnish their wages? Did they put them in a penalty box? What did they do?
The only examples of discipline that Steadfast would initiate in isolated instances would involve not allowing them to perhaps to have as many shifts as they would otherwise want during a period of a couple weeks. I think one nurse maybe even used the penalty box kind of analogy. So that would be the mechanism of discipline. And in Chow, in the cable installer's case, you had an alleged employer, right, that was actually docking portions of the pay for deficiencies that were found in the manner in which they carried out their work, and that didn't defeat the contractor status there. Here we think both the nature of the discipline and, more importantly, what led to and did not lead to that discipline was such that it still is squarely on the contracting side of the line because, again, none of the supervisory infrastructure over how they perform their work that's present in all of the cases the DOL relies on is remotely present here. It's not even close.
Can I, Judge King, just a moment to ask
Go
one more
ahead.
question. I just,
As long as you get questions, you keep.
you started off, and I don't want you to go into too much detail because your time's up, but I want to make sure I understand the scope of the argument. You started off and you gave us 3 things, and you got through the first 2, and then you indicated that 17 of the 20 workers testified. Can you help me understand what that issue is?
Yes, it's just going to the issue of, and one of the issues that is in dispute, which is whether the nurses were permitted to also pull shifts from other registries parallel with their work with Steadfast. And what I was going to say in the introduction there was that of the 20 who testified, 17 were asked whether they also worked for other registries. 13 of the 17 said yes. Of the 4 who said no, 2 of them said it was simply their own personal preference that they didn't seek work with other registries. And there were only 2 instances, both of which involved nurses whose tenure with Steadfast ended in 2017, where nurses said that they didn't pull shifts from other registries because they perceived that if they did so, it would be in tension with the Steadfast policy.
So help me understand, because the policy itself says that they couldn't do that, right? Right, and so there's like a non-compete, if we would. But so I understand, your point is, if we're looking at economic realities, the economic reality here is that they were doing this for other providers too. So once we sort of say we're not going to, abide by the fact that it says they're an independent contractor, we're getting beyond the words on the paper and we're looking at the economic realities. The evidence here shows that they were working for other people just like Steadfast.
Yes, that's exactly correct, Your Honor. And the reason it's significant is because under the control factor and the profit and loss factor of the 6-factor test, the fact that even within the closed loop of Steadfast, you have a number of discretionary choices that are not typical of employees, starting with whether, when, and where to work, the ability to sometimes negotiate rates, and then the ability to sort of go on and off the Steadfast registry as they saw fit and take travel shifts or take shifts elsewhere. That would be a lot of contractor-oriented choice, even if Steadfast were a closed loop, but it's not. Steadfast wasn't a closed loop. The vast majority of these people said it was common for them to work with other registries. Steadfast's primary registry competitor at trial, their representative, Peyton Lex, said yes. Nurses who were on our registry are on theirs and vice versa. And so when you add in the dynamic or the variable of other registries and you step back and look at what confronts these workers on any given day or any given week, they have a vast array of profit-maximizing choices that carry with potential benefit and potential risk, all of which are fundamentally absent in a typical employment relationship. And so that's why we wanted to emphasize and highlight that aspect of the record.
Thank you, counsel. Thank you, Judge King.
I've got a couple questions. You had a 7-day trial.
Correct.
Judge Jackson conducted a 7-day trial, and you had several witnesses. And then he wrote this order of January and specified, 89 findings of fact or something like that?
Sounds correct.
And you haven't challenged specifically any of those findings of fact on appeal. They have to be clearly erroneous. You say everything's clearly erroneous, basically, a shotgun approach. But don't you have to challenge the findings of fact? You're going to say they're wrong?
I'm not sure in this context that we do, for the simple reason I can use what I just discussed with Judge Richards in this example. There is a finding embedded within paragraph 42, the district court's order, that nurses were disciplined if they worked shifts for competing registries.
There's also findings in there that they were covered by workers' compensation benefits and covered by insurance benefits.
Sure.
Don't you have to tell an insurance company that they're employees to get insurance benefits for them?
I'm
That
not
they're
sure.
workers' compensation benefits for them?
I don't know the scope of.
Well, sure you do.
I don't know the scope.
That's what workers' compensation is for, isn't it? Employees?
I don't know what the scope of what.
But anyway,
That covered in relation.
but anyway, does the, have you ever read Rule 65D of the Rules of Civil Procedure?
I believe.
Has to do with injunctions, what they have to contain. They have to state the reasons why the injunction issued, state the injunction's terms specifically, and otherwise describe in reasonable detail the act or acts to be restrained or required. Does this so-called injunction comply with Rule 65D?
I think it's a tough call simply because obviously it's
Well,
concise.
it's one sentence.
It's concise in its wording, but I guess the question would be whether ordering the defendant to comply with the Fair Labor Standards Act going forward in context where it's saying that they've been classifying them improperly in the past.
The rule says specifically, and state the reasonable detail, the acts or acts restrained or be, but anyway.
I think the question would be how much can one say is incorporated by reference
But those are the requirements of an injunction.
simply through the phrase about complying with the statute. And certainly the injunction says what it says, right? It's not terribly detailed.
If it doesn't comply with it, is there any jurisdiction here?
Well, it's still an injunction, right? I don't think that rules.
Well, I'd say, it says an injunction must, the word must is in Rule 65D. An injunction must do these three things.
I've never understood Rule 65.
Well, it says that. This is the rule of civil procedure that defines, says what's required for an injunction. So if it doesn't satisfy those requirements, is it an injunction?
I would say for purposes of the reference to injunctions in the jurisdictional statute 1292B, it's an injunction if the district court calls it an injunction. That it may fall short of the procedural content that's required under Rule 65, but I have a hard time understanding how, if under 1292B, the entire point is that you can come up on an interlocutory basis and challenge an injunction. Part of your challenge might be that the content of the injunction falls short of the Rule 65 requirements, but I don't think there is a contradiction between the jurisdictional ability to challenge it and the procedural ability to say that the content of it falls short of what the district court should have done. So I do think that the word injunction means different things in those two different provisions, yes.
Well, it doesn't say it could mean different things. It just says an injunction must do these three things. Okay. Judge Dawson, you have anything else?
No, sir. Thank you.
Judge Richardson?
Can I, maybe just to follow up on that briefly? Do you have any reasonable detail, depends on the circumstances, right? Did your client have any doubt as to the act it was required to take? Right? What did the injunction require your client? What act did it require your client to take?
I took it, in the context of the opinion, it's to comply with the Fair Labor Standards Act going forward, specifically with respect to the provisions that govern payment of overtime and maintenance of records relating to the matter.
So I would have taken you to be more, yes, to comply with the act, but to treat the nurses as employees.
Yes.
Right. I mean, that seems like to me, like I'm not trying to put words in your mouth, but it seems like to me the reasonable detail here, if you read the entire opinion, it's hard to see that it's not clear that what you're required to do is to treat these nurses as employees. And exactly what that means.
Contractors under the Fair Labor Standards Act.
And then that leads to lots of other consequences. But that's the act that you're really required to do by the injunction.
Yes, I think that's correct.
But the injunction, so-called injunction, doesn't say that. It does says comply with the law. That's what I'm saying. That's what I asked you earlier. We're all required to comply with the law every day.
I think that
We have to comply with the law. And you're told in this injunction, comply with the law. So, but the Rule 65D says it has to, an injunction must provide. State what the reasons why the injunction issued. State the terms specifically. Describe in reasonable detail the act or acts to be restrained. That's what the rule says an injunction must specify.
But in this context, I'm not sure that we could have let the time for
Well,
final.
you could go on back, you could have asked the judge, it says you don't comply with Rule 65D, you can read the rules of civil procedure as well as I can. You could have gone back and said they don't do it. We want to take an appeal, and we want you to enter a proper injunction so we can take an appeal.
That's fair enough. I suppose that's a path that could have been taken by trial counsel. But at the end of the day, it's worded as an injunction. In context, I think the district court believed that it knew what it was saying to the parties, and the parties understood what its findings were. And
Well, you've been arguing about them. Last week you were arguing about them, whether you were supposed to supply the records, whether you were going to pay them as employees. There was a period of time that you didn't do it. And whether you were, what the injunction was. You were last week arguing before the district court about it.
I think the issues in front of the district court were not going to the core question of what the Fair Labor Standards Act means or what the one-sentence injunction meant in this context. It was going to things like...
It was a one-sentence injunction. You agree with that? Okay.
Yes, I mean...
Okay. And your position is that it's a one-sentence injunction, and your position is it complies with Rule 65D.
No,
Rule 65D says the contents of an injunction must be these things.
Yeah, and to be clear, I'm not saying that it complies with Rule 65D. My argument is that the jurisdictional statute that allows you to bring up an interlocutory challenge to an injunction allows you to bring that up even if the injunction is deficient and falls short of what 65D would otherwise require.
Okay, you say it doesn't, and you can appeal it even if it doesn't comply with Rule 65D.
That's correct.
That's right, I understand now. Okay. Judge Dawson?
Yes, sir. Thank you.
Judge Richardson?
Thank you.
Ms. King, welcome, Ms. King. Good to have you here.
Thank you. May it please the court, Ann King on behalf of APHALE, Secretary of Labor, which is still Martin Walsh at the moment. The district court in this case correctly concluded that under the economics reality test, the nurses that Steadfast placed in healthcare facilities were employees. I have a couple things I'd like to respond to in Steadfast's argument. One argument that Steadfast made here and in its brief is that the control factor is limited to supervision over the manner of work. But I think Steadfast understands what that means too narrowly. In McFeely, the court phrased it that way, phrased the control factor that way, but then went on to look at the employer's role in setting the pay rates for the workers in that case, the employer's role in scheduling, and the employer's role in imposing workplace conduct rules. So McFeely shows that all of those considerations are relevant to the control factor as this court.
But all right, so help me understand that, right? So if you're a company, you do agree that a company could, in theory, hire an independent contractor. That is a category of people that does exist.
Yes, Your Honor, of course.
Right? And but your argument is that if a company hires an independent contractor, that they can't have policies prohibiting sexual harassment?
No, Your Honor.
Because if they do, they're now employees. So if they do anything to limit sexual harassment or to require work-appropriate attire, or in a medical context to comply with HIPAA, right? That any time they do any of those things, that turns them from an independent contractor into an employee.
No, and I think that goes too far, but that is what Steadfast seems to suggest is our position.
No, I don't. So you don't have to put it in Steadfast words. You can put it in my words. I think that's your position.
Oh, okay, Your Honor, I disagree. So Steadfast has argued, or seems to argue, that any feature of a relationship that could be part of an employment relationship and an independent contractor relationship should not be analyzed under the economic realities test. But that can't be right because
No, but they're basic requirements. The point of this is when we look at whether you have control over the manner in which the work is performed, we don't look at the very basic requirements of sexual harassment training to say that that renders someone an employee. That there are some baseline requirements that a responsible employee would, or a responsible company would take with respect to anybody to say, you need to comply with HIPAA. It's a federal statute, right? You need to comply with sexual harassment, standards, right? You need to do the baseline things that have nothing to do with the work that you're actually performing, but that's just like necessary to be a worker in the modern society.
Your Honor, I'm hearing a couple things in that question, and one thing, I'd push back on the idea that, that again, we can't look at these sort of conduct rules or things like baseline expectations, because it's really how they're implemented. So the example of training, I think, is helpful. So if an employer had a sexual harassment policy, I don't think that would be probative of employee status if it held an independent contractor also to that policy. But to provide training on a subject is a different matter.
I'm sorry. Wait, let me help me understand. So they can have a policy, but if they take steps to ensure that policy is followed by training them on the policy, that transforms them from an independent contractor. I'm surprised the Department of Labor thinks that sexual harassment issues should only be addressed in policies and not training.
No, Your Honor.
I mean that's the message the Department of Labor or you're giving to contractors, right? Is to say if you're a company that you can write sexual harassment policies, but if you provide training on those sexual harassment policies so that you ensure that your employees are not sexually harassing others, then they become employees instead of independent contractors.
I disagree. Certainly training, and I disagree that that's our position. Certainly training.
I thought that's what you just said. You just said if they had a policy, fine. But if they provide training, no more independent contractors.
Our position is really that training on that a subject or any other subject would be different than simply setting baseline expectations of conduct. And it's really, it's probative of employee status. It wouldn't be determinative of employee status. And that's why we pointed to, I can give an example regarding the training here. So Steadfast took the role of training nurses in HIPAA compliance and in other matters. Now, if trainings like that are required, somebody has to do it. The independent contractor could do it themselves. The client, which would certainly be a thumb on the scale for independent contractor status. The client facility could do it, or the agency that places nurses could do it. Now, here it was the agency that provided that training, and so if it could be different if the nurses took on that practice of seeking out training for themselves. But I don't think, we are not trying to take the view that setting baseline expectations, or even that providing guidance or training on that is definitive as to independent contractor or employee status. I can back up for a moment and just emphasize again that this is a totality inquiry, as this court has emphasized in McFeely and Schultz and other cases. No factor is dispositive, but it's not meant to be a checklist or a mechanical inquiry, but it's something where all the facts are analyzed. And so to the extent Steadfast is suggesting that features of both independent contractor arrangements and employer relationships can't be considered in the totality inquiry, well, that would carve out very little that's left for the totality analysis. And again, as I think there's some helpful.
Can you help me? Can you help me understand a factual question?
Yes, Your Honor.
Your colleague started talking about it, and I had a question about it. So when I look at paragraph 42, where Judge Jackson says that employees were disciplined for working with other registries, and I looked at the record sites, or tried to look at the record sites that he provided. I had a little trouble finding the evidence that Steadfast disciplined its nurses for working for other registries. Can you help me find where in the record that finding was supported by any evidence?
I believe some of the strongest evidence of discipline comes from Courtney Drawn, who worked in the office at Steadfast. So she wasn't a nurse, and she didn't have an interest in either way. But she witnessed Lisa Pitts, who is the owner of Steadfast, disciplining nurses. I also just want to...
But my question is quite specific, and I think, at least I don't recall her testimony on this point. The question is, was there evidence that nurses were disciplined for the very specific reason that they worked for another registry? Like that's the question, because the record, as far as I can see it, has no support for that conclusion. I mean, I tried to look at the record that was cited. I found nothing, and I just want to make sure that I'm correct, that there is not a shred of evidence that supports that conclusion.
I'm looking at our brief at page 37, and Drawn specifically testified about Pitts disciplining nurses for contacting client facilities.
And is contacting client facilities working for another registry?
Well, I think that is related, and I would also just like to point out that our view...
I'm sorry, before you go to the next point,
Yes, Your Honor.
do you agree with me that there is no record evidence that any nurse was disciplined for working for another registry?
No, I don't agree with that.
But okay, before you go to your next point, can you point me to where in the record I could find that?
I would think the best place that I could point you right now would be our citations on page 37 to 38 of our brief.
Thank you.
And I would also just like to point out that it's our view that the mere existence of the non-compete clause, regardless of whether it was enforced, is a very strong indicator of employee status. And for that reason, it's not something that you would typically see in an independent contractor arrangement where an employer, a putative employer, prevents the worker from working for other entities. And really, that brings us back to the core question here of the economic realities test. The question is this worker working for the company's business, or is the worker in business for themselves? And when a worker is subject to a non-compete clause, even if it's not enforced, that could be chilling to the worker. That is a strong evidence, again, very probative of employee status, that they are not working in business for themselves.
Ms. King, you've already conceded, though, that that is not unique in any venue, whether it's an employee status or if it's an independent contractor. You've also said that there's no one factor that's dispositive of all. So we've already talked about two where I haven't really heard a specific answer as to why it weighs in favor of your position. One being the non-compete, and the other being the discipline. So as we start to check off the items where it's not really clear where they weigh in your favor, aren't we running out of items to discuss?
Well, Your Honor, I would push back on the idea that neither of those items are probative. But if the court disagrees, then I could point to, again, I think it's helpful to look at McFeely, which again considers who set the pay rate, workplace conduct rules, and schedule setting.
So can I ask this question on the pay rate? If you're an independent contractor, whoever's hiring you is setting what they're going to pay you. I'm having a little trouble understanding why that cuts one way or the other.
Well, I don't think that's always true, Your Honor. I have a tree that I need to have cut down in my backyard, and I just got several bids from independent contractors, and they were different. So then I have the opportunity to choose which one I would like to accept. So one reason it goes to control is that a worker's pay is sort of part and parcel of the relationship between the the putative employer and the worker. And again, it goes back to this: are you in business for yourself, like the tree workers who gave me bids that they themselves have the opportunity to set, or are you accepting a rate that someone else has negotiated and working for that employer?
Can I ask you about a case, and it's not a game of gotcha, and if you're not familiar with it, you can just say, I'm not familiar with it, right? I'm not trying to play that game. We decided a case in 1997 called Celiac versus Innova Health Services, or Health System Services, one direction or the other. Are you familiar with that case?
No, I'm not familiar with that case. Okay. I'm happy to answer any questions about it.
Yeah, so it's a case about whether an emergency room doctor is an employee or an independent contractor, right? And it talks in great detail about the unique nature of the hospital setting. And among the things it talks about is this idea that if you're a hospital and HIPAA didn't exist in 1987, but the equivalent of if you're a hospital and just because you require compliance with federal law, that doesn't make you an employee, right? And that in fact we have to look to the nature of the location to understand what really cuts one direction or the other. And it's focused on control, but it talks about a number of other factors as well that strike me as quite analogous to what we have here. I mean, and there they found that the emergency room doctor was an independent contractor and not an employee, even though I think in ways much more significant than here, the hospital controlled what the emergency room doctor did. And so I'm having a real hard time squaring your arguments and the district court's conclusions, not the factual findings, but the conclusions with our decision there. And I get that, the district court didn't have the benefit of that decision. The parties have not briefed it, but I'm not trying to ask you to sort of comment on it, but I wanted to give you an opportunity to respond to it if you wanted to.
Well, without knowing the details of the case, it strikes me that the opportunities for profit and loss factor might be relevant here in distinguishing the emergency room doctor, because that factor.
Yeah, help me understand why, because it seems to me that the doctor there wasn't like paid on a contingency, right? The doctor wasn't like, if the guy lives, you get $100, but if he dies, you get $50, right? Like, I get that, right? Okay, like,
that would be a surprising payment structure.
Right. Department of Labor might have other concerns about that. I totally get it, right? But it looks a lot like the sort of payment structure we've got here, right? That, the hospital is, in this case, is the hospital, not a service, but the hospital's setting the pay rate, right? But, that doesn't make a difference there.
Well, I generalizing about what I know about doctors and sort of practices of work of doctors, what I meant was that the emergency room doctor maybe does not work, maybe engages in outreach, advertising, marketing to market himself to different hospitals, and would, by virtue of the fact that he applied managerial skill, potentially have the ability to maximize his profits. Here, there's nothing of that type, and I think it's also important to that factor to emphasize that the nurses didn't bear any downside risk, which is an important feature of independent contractor relationships. Again, it goes back to that question: are they working for the business of Steadfast, or are they in business for themselves? And many doctors are in business for themselves and engage in that type of marketing to obtain opportunities.
So one of the points in that case was that doctors are often exercising independent judgment, and I would have thought as a natural matter that so too are nurses, right? And I'm not trying to get into the debate about the relative value of doctors and nurses, although I think many nurses think that that's reversed. But it seems like to me that doctors, and the court recognized there, exercise lots of independent judgment. And so too, at least I would have thought, nurses exercise independent judgment about what to do, when to call the doctor in, how to treat situations that a doctor's not involved in. And so what I'm curious about is the district court made the finding that nurses, and this is paragraph 43, nurses do not exercise independent judgment. And I guess I'm sort of curious about that factual finding as well, because I didn't see that supported in the record either. And I get it's not a good reason to question something, but it runs counter to my intuition that nurses exercise all sorts of independent judgment. And so is there somewhere in the record that I could point to suggest that the job of a nurse or the job of these nurses involve no independent judgment?
Just to start off, Your Honor, I don't think that any exercise of independent judgment would defeat employee status.
Yeah, I agree. I'm just looking at the factual finding, right, that says that the nurse exercises no independent judgment.
Yes, I think, as I recall, the citations here go to the sort of the idea that these were very general nursing tasks that the nurses performed versus an ER doctor might make a high-level decision. And again, I'm not commenting on nurses versus doctors, but one thing.
I mean, was there really evidence? I mean, it's hard to I confess finding these citations is not super easy, right? Because they're transcript and PX numbers. But in the efforts that I made to do so, I didn't find any evidence to support the idea that nurses make no independent judgment when they're doing that, right? That maybe it's less independent judgment than a ER doctor, but to say they exercise no independent judgment, I didn't see that in the record, and it is strongly contrary to my view of the role of a nurse in a hospital. And I get this may not be dispositive of the question, but I just want to understand, if we generally defer to these factual findings, and if it's true that a nurse exercises no independent judgment, that's one thing. If they exercise less independent judgment than a doctor, that's a very different thing for our calculus. And so if there's record evidence that there was no independent judgment exercised by any of the nurses in this case, I'd like to know about it.
Your Honor, I think it's that evidence that that the district court had in mind that these nurses were performing very routine tasks. But can I emphasize something else that I think helps shed light on that? So the placements here were temporary placements where healthcare facilities needed someone to fill in. And you're not, it's reasonable to think that these facilities are not going to ask for these temporary workers to exercise a great deal of judgment. It's just sort of the nature of...
That might be true, maybe not a great deal of judgment, but to say they exercise no independent judgment, I mean, that's a really strong, that might work if you're making widgets, right? So if you're your job is on the assembly line and you turn this screw 2.5 times and it goes down the line and you turn this screw 2.5 times, right? That guy might not be exercising independent judgment, right? But to say a nurse exercises none.
I think that any job, if you're looking at it that broadly, it seems like any job would involve some independent judgment. What I think could be helpful here is to consider this in the lens of the economic realities test. Are the nurses exercising independent judgment in the sense that they are making decisions about the business for themselves? And they aren't really. They're engaging in routine care. I know I keep repeating that phrase, but I think that lens is important to think about. Are these workers in business for themselves, or are they working in somebody else's business? I'm happy to address any other questions.
Well, I want to hear about jurisdiction.
Yes, of course, Your Honor.
And I want to know why y'all are still litigating down there when there's an appeal pending here. An appeal, as a general proposition, stops things in the district court, except to act in aid of the appeal. Do you recognize that?
Yes. And it's my understanding that the district court is believed that it had jurisdiction over the ongoing, despite the pending appeal, over the ongoing show cause and post-trial back pay proceedings.
And you all were still litigating. And you had bond proceedings, although
Yes.
the brief says they stopped. And nobody ever told us anything different.
Well, the bond proceedings were are actually more related to the appeal to attempt to sort of freeze things in place while the appeal is pending. So I don't think those are inconsistent with the appeal. We don't.
So what do we have jurisdiction over?
In our view, that's we don't disagree with the idea that this court can hear, with steadfast contention that this court can hear an appeal over the injunction. I would like to point out also, though, that the district court's opinion that we all know so well does award back pay and liquidated damages, and steadfast had not contested up to that time the back pay calculations by the department. And so that is why the district court said that steadfast owes the back pay calculations as calculated by the department. Now, after trial, they have.
Now, that's not part of the injunction, is it?
It is. It's not part of the injunction because
Not part
that's
of
a
it. So we
damage.
don't have any jurisdiction over that. Is that if you agree that they have jurisdiction to bring this appeal,
We're not contesting their jurisdictional statement.
so it's up to us to contest it. We have to contest it because we always have to be satisfied that we
Of course.
have jurisdiction. Does it satisfy Rule 65D?
And Your Honor said that has to do with
I said it. You're the lawyer here for the United States of America. You know what it says.
that it has to have a clear statement of that an injunction has.
It has to be an injunction. And to be an injunction, it must satisfy these criteria.
I'm not. I don't have a direct response to that at the moment. I do agree with Judge Richardson's suggestion that the sort of core of the injunction is that it would enjoin treating the nurses as
So you-
independent contractors.
So you say we could just ignore Rule 65?
I would not contend that. No.
So the word must doesn't mean must, doesn't, in the context of Rule 65D. And the fact you're still having proceedings that you haven't told us about.
And I
And arguing,
that we
and,
didn't apprise the court more effectively.
and arguing about a variety of things, looked to me like. Isn't that correct?
Yes.
As to this case.
The bond and the post-trial back pay calculations.
Is that all?
I believe those are the core issues.
How about the
Maybe
records? How about the fact that the government claimed you hadn't been supplied with the records?
Yes, there.
But you claimed, is that not true?
I would have to confirm that, Your Honor.
Were you at the hearing
If you
last
say
week?
So, I was not at the hearing, no.
You were not at the hearing last week.
We have a trial team that had focused on that.
Well,
but
you're
if
the
Your
only-
Honor, if
You're the
it-
only lawyer we have here to talk
Yes,
about it.
that's true. If Your Honor found that there was a record issue as well, then I'm sure that's correct.
So I think they talked about records or motions about records not being disclosed and or provided and anyway. I was just sort of flabbergasted that injunction says you have to comply with the law.
Yes, to classify the workers going forward as employees.
No, that's, you're adding to it. You're explaining it. And you agree that there's a right of appeal from that statement.
Again, we're not.
That somebody has to
contesting
comply
it.
with the law, and they can take a right of appeal. And
Again, we're not contesting it at this.
Ms. King, but
at this
let me
stage.
make sure I'm clear.
Yes,
Are
Your
you
Honor.
then asking us to infer what the injunction is so that then we can therefore have jurisdiction over it and we can address the issues that have been argued about today? Because I am struggling a little bit with the concept of, do we have to get you there versus you presenting it to us?
I don't think that the nature, the contours of the injunction require significant inference, because the underlying claim here is whether Steadfast the underlying issue is whether Steadfast correctly classified.
And so there was an order issued in that regard.
Yes, and
There was a declaratory judgment, is what I would describe it. You got a declaratory judgment that they were employees,
yes,
and you didn't need an injunction.
and
Because
here,
everybody has to comply with the law. Everyone has to comply with the law, whether they're in court or not. We're all
Yes.
obliged to comply with the law.
yes,
But if
of
you
course,
want
Your
to
Honor.
if you want to enjoin something, to require something or restrain something, Rule 65D says you have to do these things. You have to specify. You must specify and be particular. That's what it says. And it seems to me like you agree, and you all have a agreement you want to bring an appeal. Which would mean that if you don't really have a right of appeal, we're given an advisory opinion on things.
I certainly understand your concern, and there isn't any agreement.
And we love having final order appeals. We don't like piecemeal appeals.
I don't know if this is helpful, but in terms of the inference question,
The which?
the question about inferring the nature of an injunction.
Good question, yes.
Yes, I agree. So one thing that's
Which is what your friend on the other side basically said, and what you agreed with, that we need to infer what the parameters of the injunction are, and go forward as if this is a proper injunction appeal under 1292A1.
Can I clarify my response slightly?
Oh, yes.
My response is more that if this court believes that it would be necessary to infer the nature of the injunction, I think that is a simple inference, because the sole issue was the classification issue. There is no dispute over whether workers worked over 40 hours a week, and there's no dispute that none of the workers received overtime.
Oh, no, go ahead, sir.
So I thought your answer was going to be slightly different, right? Which is that the injunction is not quite as broad, right? It doesn't say comply with the FLSA, right? It says that the defendants are enjoined from committing further violations of the FLSA. And that follows 29 pages where the district court described what the defendant was doing to violate the FLSA, right? And so I thought the inference came from this idea of further violations, right? So it's gone through and it's described over 29 pages. And it's true, the one sentence doesn't give us much, but the reference to committing further violations tells us that we're not talking about just generally comply with the law, right? We're talking about the violations that have been heretofore just described in the previous 29 pages.
And that approach may sort of narrow the scope of the injunction.
There's the scope of the injunction that makes it even less necessary. But you have a declaration by the court that they're employees. A declaration, a legal ruling, which in the absence of an injunction could be appealed as a final order appeal. But you get that extra language in there, however you construe it, whether you infer it or whatever you do, as limited as it is, don't violate the law anymore. Then you can appeal that and argue we don't want to be bound by an injunction that tells us not to violate the law anymore.
Yes, and
they're not really, the injunction really doesn't have anything to do with the declaratory relief. It's don't violate it anymore. The FSLA, that's the statute.
And I think Your Honor may be putting your finger on something else that occurred to me, which is that we're all required to follow the law. Companies are required to follow the FLSA, but there is a difference between a court order stating that, as Judge Richardson said, stating reasons why the court believes that the entity was violating the law and directing the entity to comply going forward.
Makes them subject to contempt.
Yes,
right?
exactly. So it can be enforced.
You could get a show cause order.
Exactly.
It's something we're familiar with here.
Well, you could get that whether you had an injunction or not. You could get that whether you had an injunction or not.
Under a declaratory judgment, is that what Your Honor had in mind?
Well, you had the declaration. You have a declaration. That's what you have here. A declaration after a 7-day trial, a legal conclusion that they're employees. And then this injunctive language, which you asked for in your complaint, is, it seems to me, the absolute surplusage.
I'm not sure if that's right. And I know
Okay.
that one reason we tend to request injunctions in our FLSA complaint is
In the absence of it, in the absence of it, they could have filed a notice of appeal from a final order.
Yes, so certainly that would be a route that would be available.
That's right. And so they did it this way, and you get a 1292B, and you don't have a final order, and you're still litigating, and we're litigating. Here, you had a hearing in the district court last week in Norfolk, and all the lawyers were down there, and now you got another one up here, and it's going to go on for, we don't know, who knows how long.
It's a difficult question. I think
It's not a tough question to me. The district court supposed to handle the case and then comes up here with a final order.
And the district court is taking.
And if you try to appeal an injunction that's not an injunction, then you don't have an appeal. You can come up here and argue about all the stuff, but what does and they don't say that anything is, any finding of fact specifically is erroneous.
I agree. Yes,
I mean,
Your Honor.
Judge Richardson's minded pretty well, I think, for them. They don't lay out and say anything's legal, factual error. They have to be clearly erroneous. He had, what, a 7-day trial and made findings of fact and conclusions of law. Said they're an employee.
Yes, Your Honor, we agree with that.
But then you added this one sentence to it. Don't violate the law anymore, which I thought, well, that's like my mother telling me to stay out of trouble. Then I should know better. Well, they should know better too, after he tells them, but they have a right of appeal. A right of appeal from a final order appeal. We don't have a final order, and you all are still fighting over records and bonds and I don't know what else. But anyway, Judge Dawson.
I'm satisfied. Thank you.
Judge Richardson.
Satisfied.
Thank you,
Okay.
Your Honors.
Thank you very much, Ms. King. Mr. Pafford?
Yes. So three overarching points that I hope to be able to make. First, with respect to the question of whether we're challenging specific district court findings, I think this intertwines with the argument we have made clear in our brief about the burden of proof and the scope of the allegations. For any finding in isolation, other than maybe a couple, which we again challenged in the briefs, the whole question about whether they could work for other registries, it is possible for some of these findings that there might be some shred of evidence somewhere in the record that in one particular instance something happened that way, right? But fundamentally, that's not the question before the court. The question before the court is looking at the 6-factor test, looking at the scope of the allegations, looking at the department's burden of proof, which the department hasn't contested. Can we say in the aggregate that this classification decision that our client made was incorrect? And we think the answer to that is plainly no for a lot of the reasons we've talked about today. Second point I want to make ties to the substance of some of the discussion, Judge Richardson, that you had, and Judge Dawson, I think this was referenced in some of your earlier questions. I think the question of independent judgment goes to the second factor of the test, which is the opportunity for sort of profit and loss and whether they're making choices. And a lot of that evidence here doesn't so much turn on the skill the nurses have, which I think they have to exercise a ton of skill. We'll get to that in a moment. But the independent judgment they're exercising, as we've noted, is in the context of a wide range of choices they have to make on any given pay period about the opportunities they have not only within the steadfast loop, but from other registries outside of it, and all of the variables that they factor into that decision making. And if you were to look at the testimony from Christopher Ryan Hobson, Sandra Boykin, Dawn Wooten, Courtney Turner, Penny Clark, Napoleon Alston, Daceline Hall, Charlotte Lee Coates, these are all nurses who testified at trial and testified at length about the different things they do through Steadfast and other registries to maximize their profits, to assess trade-offs, and to make these decisions that carry with them risk and carry with them benefit, which is exactly what the test is talking about. And we believe that the level of control they're exercising over their income-generating activities, which is what the test is about, is certainly equal to or greater than what the cable installers were doing in Chow under a very similar structure. Third point I'd like to make is that with respect to this question of skill, I would just direct the court to the best example is pages of 733 and 34 of the appendix. Tawanda Hall, one of the LPNs, is testifying. So this is someone who's below an RN, but they're an LPN. They're still a nurse. And she says, you have to know how to read a doctor's orders. You have to know what medications and what they do for the patients. You have to know some of the critical values of labs. You have to know how to deal with tracts, which I guess are tracheotomy tubes and G tubes. And you have to know how to treat dialysis ports and things like that. Given that type of work, given the context of a lot of this working activity in the later years of the case happening during COVID, I don't think there's any dispute that these are skilled workers under that prong of the test. And the district court found, indeed, that they were skilled workers. It just found, we believe wrongly, that that factor was outweighed by others. Final point I'd like to make is that on this question of the degree of control, imagine if the record were different. Imagine if the record here showed that Steadfast was exercising rigorous control over the schedules of the workers, was making them turn in medical notes and treatment plans, was doing site visits to the medical facilities where they worked, was employing on its own payroll medical liaisons to engage with the facilities, and had a detailed policy and procedures manual that governed how they did their nursing work. All of that was present in Gale, Hughes, Crouch, and LeMaster, which are the cases DOL relies upon. If that were present here, DOL would of course be pointing at it, and they would be arguing that it was outcome determinative. Yet strangely, the absence of any of those factors here, and instead all of the discretion that the workers have, doesn't seem to change the calculus, because the calculus for DOL seems to be a moving target. And this court in McFeely emphasized that ultimately these questions come down to things where courts have to struggle with matters of degree and not make categorical pronouncements. And fundamentally, we think that is the flaw at the core of the district court opinion, is that rather than analyzing the details and the degree in the record on the core factors and measuring it against this court's precedents, particularly the structure in Chow, which is strikingly similar to the structure here, it just sort of found a bunch of facts, didn't sort of explain where they fit in under the precedent or the six-factor test, and instead shaped its analysis primarily around a bulletin that came out after the complaint was already filed, and that neither side argues is binding or determinative in this context in any event.
Can I ask a question about the 1292 issue?
Sure.
I don't want to make sure I understand your argument here. 1292 allows you to appeal an injunction. And your argument effectively is that when the court says we enjoin Steadfast from further violations, that is an injunction. That allows you to then appeal, right?
That's correct.
And then...
And we argue that injunction...
Wait. Bear with me. I'll let you fill in as soon as I finish, all right? So that allows you to appeal. And then on appeal, there are an array of options available to you to challenge that injunction. You might say that it fails on the merits, right? The merits that underlies it is wrong. You might say the balance of equities, right, wasn't properly weighed in deciding that an injunction was appropriate, right, in light of the other remedies. You might also say that Rule 65 was not complied with, right? All of those are arguments that are available to you on appeal from a given injunction.
Correct.
Okay, and here you have not made the Rule 65D argument, even if you could, but that's just a procedural issue that you chose not to raise.
That's correct.
Right. And you've not argued here that the balance of equities wasn't properly weighed by the district court, although you could have, right? And so that argument is waived, right? The only argument that you have made is that the merits determination that formed the foundation of this injunction was fundamentally flawed.
That's correct. And if you look at page 30 of the district court opinion, under the section labeled injunctive relief, the last sentence right before the conclusion of the opinion says, therefore, plaintiff, the Department of Labor, has shown good cause for enjoining defendants from violating the FLSA's overtime and record-keeping provisions. Our appeal is meant to tackle that head on and say that the plaintiff did not show good cause because the classification practices that we engaged in were correct, and we should be able to maintain those practices going forward and not have them be deemed violation of the overtime or record-keeping provisions. And that is the argument that we have made challenging the injunction that was entered by the district court. And we think that under 1292A1, that gives this court jurisdiction, notwithstanding that this is not a final order because of all the back pay issues that Judge King has alluded to. One record point I just do have to clarify.
You agree that the back pay is not before us?
That's correct.
That's not in this appeal. So the good faith point that you raised in brief extensively about the conferring with a lawyer at some point is not before us.
I think the only way the good faith point would
I mean, you briefed it all.
I think the way it would be before you, though, is under this court's case law about pendant appellate jurisdiction, because the merits arguments and the question of whether we had reasonable grounds for the classification decision are so heavily intertwined. I think under a pendant jurisdiction theory, the court could reach that if it found it necessary to do so. One record point I just want to clarify for Judge King.
So you're saying the good faith is before us?
Yes, I think it is.
And you're saying but you're saying the calculations are not before us?
That's correct.
So it is a piecemeal appeal?
In that sense, it's piecemeal, yes.
But you have not briefed jurisdiction. The jurisdictional question is not briefed here by either side.
We tried to brief it.
No, you didn't brief it. You made a statement. You made a statement that it was under 1292A1. And the government agreed with you.
But in the context of that statement,
So
we did identify.
then the question is, what do we do with that? And,
I think our
and if we have an obligation, whether the lawyers agree or not, to look at jurisdiction first, always, first and foremost. Otherwise, we're giving an advisory opinion, or we're conducting proceedings, and you're writing briefs that are unnecessary. That would resolve it all then, rather than now.
2 points, if I could. One, I think our jurisdictional statement did anticipate this issue and identify for the court the back pay issues that remain pending and explain that that's why we believe 1292A1 was the proper foundation for jurisdiction. Number two, this is just a record-keeping issue. I know Your Honor.
You didn't say the back pay issues are not pertinent to this appeal. You didn't say that the good faith was pertinent to the appeal, did you?
We believe good faith is. I think we tried to say that the back pay issues were not before this court, and they certainly.
Well, the back pay issues were still going on, you said. They were still going on. But you argue about them.
I don't think we're arguing about the computation.
You say that all that is in aid of the appeal?
What's going on below?
What's going on below?
No.
Okay. Okay.
I think there was a non-final order that nonetheless had an injunctive provision that allowed us to come up under 1292A1. The one thing I want to clarify, because there is a lot that has gone on below, I just want to clarify this question that was addressed in the hearing last week about records. That is not the subject of motions practice. The issue there is there was a July 14th letter, not a subpoena, not anything that was covered by the order, asking for some additional post-trial records that were outside of the scope of the court's order. We replied on July 28th, attempted to negotiate, and didn't give them the records. DOL never replied to our July 28th letter, and now things have gone a bit sideways, as you can tell from having read the transcript of last week's hearing. My only point is, I think that that entire issue doesn't have much to do with any of the briefing that's on the district court docket or any of the stuff that is still being addressed down there on back pay. I just wanted to clarify there were no motions, or there's no disputed motions practice at present in the district court on a pending discovery request or a subpoena or something like that.
Okay, so your contention of appeal doesn't cover the back pay, it does cover the good faith.
That's correct. And again, I think that the theory on why good faith.
But the good faith, okay,
If it needs to be reached, is simply a theory of pendent appellate jurisdiction, because the question of our reasonable grounds for the classification and the question of whether the classification decision is correct on the merits are heavily intertwined. If we win that the classification was defensible and correct, or that DOL hasn't carried its burden of proof, you don't have to reach good faith at all. But if the court were to rule against us on the merits, then the question of how close were we, did they take reasonable steps, was this a defensible good faith position, becomes it becomes a vital predicate of what you have to analyze for good faith. And so we think under this court's pendent appellate jurisdiction case law, it could properly consider both of those inquiries if it needs to reach them. Again, we believe you should rule on the merits in our favor on the classification issue, which is ultimately a de novo question, and that you will not need to reach good faith. But if you did find that you had to reach it, that would be my theory for why jurisdictionally you could do that.
thank you very much. We appreciate the arguments of counsel. The matter will be taken under advisement. We'll come down and greet counsel, as we've done for years and years. We're back to doing now after the pandemic, and we will take a short break. is number 21-2018, Hardcastle versus Hardcastle. Mr. Ohana?
Morning, Your Honor. May it please the court, my name is Jason Ohana. I represent Mary Lee Hardcastle, the appellant in this matter.
Good to have you with us, Mr. Hardcastle.
Thank you, Your Honor. The question on this appeal is whether the district court can issue injunctive relief to a defendant that the defendant didn't ask for, especially when the defendant doesn't have a counterclaim. There's no pending claim for relief. The defendant hasn't filed a motion for injunctive relief. Whether under those circumstances, also the defendant hasn't posted bond as required by Rule 65, whether under those circumstances the district court can sua sponte issue injunctive relief. And our position is that the district court cannot do that. That's supported by an 11th Circuit decision that we quoted in our brief, Reynolds versus Roberts, in which the court held the question presented in this appeal is whether the district court may sua sponte enter an injunction that affects the legal rights of the parties without either one, entertaining evidence and ruling upon the objections of the affected parties, or two, obtaining consent of the affected parties. We hold that such sua sponte entry of an injunction is improper. We therefore reverse. We're asking this court to do the exact same thing here, to hold that the sua sponte injunction granted to the defendant who had no pending claim was improper, and to reverse. By way of a statement of facts, this case involves essentially two different trusts and two half-sisters. The cast of characters I think is important to have in mind. Mary Lee Hardcastle and Miley Hardcastle are two half-sisters. Miley Hardcastle is the sole beneficiary of a trust that was settled by my client's mother, by Mary Lee's mother, Mary V.M. Hardcastle, who we refer to as Mrs. Hardcastle in the brief papers. That estate, that trust to which the estate poured into, incurred an estate tax liability, which in 2017 was believed to be around $859,000. The trustee of the Mary V.M. Hardcastle Revocable Trust sent a bill over to the trustee of a separate trust, the Charitable Remainder Annuity Trust, or CRAT, which is the subject of this case. The trustee of the CRAT is John Midgett. When John Midgett received this bill, this tax bill, he said, well, the CRAT can't pay this out of the trust funds, because if the trust does that, it loses its charitable status and it loses its tax-exempt status. So that will harm the charitable remaindermen, and it will harm also the annuity beneficiaries to the extent that what had been a tax-exempt trust is now not. The IRS provides guidelines on what to do in this situation. There's IRS ruling 82-128, which provides that a trustee can amend a charitable remainder annuity trust to make the lifetime beneficiaries opt to either pay the tax and stay in the trust, or just simply opt out of the trust and say, I'm not going to pay the tax. So,
How does your client have standing here, or how do we have jurisdiction here?
okay,
Two questions.
start with standing. So standing obviously typically requires a party to have standing to bring an appeal. There are exceptions. One of the exceptions is set out by this court's Quinn versus Quigley, Doe versus public something or other. It's in the brief. And what the person has to have is a legal interest in the case and have been privy to the proceedings of the case. And both of those factors are met here. Mary Lee Hardcastle stands to lose $1.3 million in annuity distributions if she loses here, so she has plenty of economic interest in the case. The court below, in her initial motion to intervene, ruled that her position was adequately represented by the trustee, and it may perhaps have been for a time. We disagreed with that position at the time.
But you didn't appeal that position, though, for
We
whatever
didn't appeal
items that
that.
you disagreed with.
Correct. We did not appeal that ruling.
So she was not a party to the case below.
Correct. We also, as soon as the injunction was issued, we moved once again to intervene, but the court simply didn't take up our motion.
But were the issues that you disagreed with when you initially filed your motion to intervene, what changed?
What changed was the entry of an injunction that we needed to appeal.
Yeah, but what about the posture that you were in when you filed the original motion back in, I believe it was in 2018, that the court denied? What were the issues that you were concerned about then, and were those issues still present when the court issued its order where you then have now filed this appeal?
The issues were not present at that time. At that time, there was no counterclaim by Miley Hardcastle seeking any kind of injunctive relief. In fact, there never was. So there didn't even appear to be a possibility that the court would enter an injunction that would require the trustee to give us.
But wasn't it possible the court would find that the amendment in the notice provisions was inadequate? And therefore, if it was, it would put you in the position that you're in today, that you would not realize the windfall of those additional annuity payments in the future?
I would respectfully disagree with the characterization of it as a windfall.
All right, but part of your argument today is that there were future benefits that you would realize if, in fact, the amendment was in place and the election to opt out was held in place. There were
Right.
additional monies that you would have received.
I don't think that that was in the offing, because the only claim that was before the court, the district court, was the trustee's claim against Miley to recover the previously paid, the distributions made before the amendment. There was no claim pending for example, reentry into the CRAT. Now, Miley did attempt she did move to amend her answer to add a counterclaim, to add exactly that kind of claim, but it came much too late, and the district court correctly denied her motion to amend her answer and add that type of counterclaim. Had that counterclaim been present, yes, we would have had that exact issue, and that may have prompted us to appeal at that time, the denial of our motion to intervene. Although we may not have needed to intervene, because in her proposed counterclaim, she included Mary Lee Hardcastle as a defendant. So the intervention, I would say, would probably be moot. We would already be a party had the court granted Miley's earlier motion to amend and add a counterclaim.
But before you leave that, as I recall in your initial motion, you raised the argument that you felt that your client's participation, if you were left out, could impair her ability to protect her interest in the annuity distributions, and you say in several ways. And you say, first, the amendment could be invalidated, and you say at a minimum, this would result in Mary Lee receiving only half of all future annuity distributions and none of the pre-amendment distributions. Isn't that the same position you're in today? You raised that argument then. The trial judge says, no, I think you're adequately protected. You don't appeal, although that was the argument that you raised. Isn't that the same position you're in today?
I suppose we could have appealed at that time and said we could still face this, even though there's no claim for that. We could still face this if the court were to find that the reason the trustee can't collect the previously paid distributions is because the amendment is invalid. I suppose we could have appealed at that time. We did not.
All right.
What should have happened when the trustee sent notice to the parties, and the trustee sent notice on August 11th of 2017 to both Mary Lee and Miley, what they both should have done is ponied up their half of the estate tax reimbursement, and all of this litigation could have been avoided. Not just this case, but there's a separate case by Kevin Rack, who's the trustee of the revocable trust, to which Miley is the sole beneficiary, in which he's suing the charitable trust for the full $859,000. Both of those cases would have been avoided had Miley just done what she was supposed to do and agreed to carry her half of the tax. But she didn't do that, because what she wanted was for the charitable remainder annuity trust to pay all of the tax while she kept receiving benefits, and then leave my client, and leave especially the charitable remainderman in the dust when the CRAT lost its tax exempt status. So when that failed, I think she looked for a lifeline from the district court, and the district court improperly granted it to her. That's what we're here for on this.
You mentioned first that you were going to address standing that Judge King raised, but Judge King also asked, I believe, why we have jurisdiction. In other words, you keep referring to this order as an injunction, but it doesn't say that. It might have the effect of being an injunction, but it doesn't say it's an injunction itself. So help me understand why under 1292, a provision we've talked about a bit this morning already, but maybe a little bit more will help us, why this is the type of order that has the effect of being an injunction that is appealable under our case law.
An injunction is an order by a court to somebody to either carry out some act or to refrain from carrying out some act. That's exactly what this order did. It ordered the trustee, John Midget, to issue a second chance notice and then to give Miley this second chance to participate in the CRAT and finally pay her half of the estate taxes. That's I think, a pretty textbook injunction, and that's why we have standing to appeal it as an interlocutory order that grants an injunction.
If we were to determine, just want to understand the framework, you argue that it is an actual injunction, but if we determine that it was only an order that has the effect of being an injunction, and those are sometimes permitted to be appealed, do you have an argument that Mary Lee has irreparable consequences as a result of this order? We've sort of said, just to put the framework, if it's an actual injunction, you can appeal under 1292 without an additional showing. If it's an order that has the effect of being an injunction, the courts have said you also have to show irreparable injury in order to appeal, right? Because it's not an actual injunction, it's just effectively one. I understand your first argument is this is actually an injunction, but assume for a minute, hypothetically, that I disagree with you on that point, and I believe it's only an order that has the effect of being an injunction. In that scenario, can your client show irreparable injury, irreparable consequences as a result of that effective injunction?
I think I'm familiar with the case law Your Honor is referring to, and I'm pretty sure that case law only requires a showing of irreparable consequences where an order has the practical effect of denying an injunction. This is different. This order either was an injunction or had the practical effect of granting.
All right, so I'll accept that argument to say that my hypothetical is not true, which might be right. But if I believed that you needed to show irreparable consequences in order to appeal under 1292, do you have an argument that your client has shown irreparable consequences?
We do. I've included in the brief, there was a citation, I can't remember the name of the case, it's from the Second Circuit where the court held that, I think it was something very similar to this, where a beneficiary was not going to have access to her money or her financial resources and not be able to direct them the way that she wanted for some significant period of time. That's irreparable harm, especially when you get to somebody that's the age of the people.
But why is that irreparable, right? I mean, I get that it's a harm, right? So we often talk about, a denial for a period of time is a harm, right? But it's also reparable.
Again, I would refer to that case. The case was you had somebody that I think was on in years and lacked access to and the ability to use their property in the way that they would want to, or in the ways that would be advantageous or beneficial to them. In this case, right now, to this day, my client has, I think, $460,000 of assets sitting in escrow, ready to pay the half of the tax, and she also has to be prepared, if she prevails here, to have the other. Actually, she's paid half of it, and she has to have an escrow the other half in the event we prevail, and she owes what would have been my lease half. So she's out all of that money, and she can't touch it until this is resolved, which other courts, the Second Circuit has held as an irreparable harm. The court, in granting the injunction, did it on summary judgment, and the basis of it was that the notice, the quote 10-day notice, was unreasonable. We think that there are, at the very least, substantial, factual, genuine issues of material fact on that question that was not appropriate for a decision on summary judgment. Number one, there were 52 days because there was the August 11th, 2017 letter that notified the parties that this was coming down the pike. Number two, the trustee had a good reason for the 10-day notice. The court acknowledged his reason, and that was that he was being sued by Kevin Rack. He was being sued by the revocable trust. I see my time is up. May I continue?
You can finish your thought, or go ahead.
Thank you. He was being sued, and he had to file an answer, and then he also had to file a third-party complaint against whoever was going to accept the tax liability, which he ultimately did. My client accepted the tax liability, so he filed a third-party complaint against her to cover the tax if the CRAT was liable for the taxes. The district court acknowledged that, but said, well, but that case was later stayed, so in hindsight, that wasn't really necessary. It wasn't reasonable, which I think all of us would agree that we don't measure the reasonableness of somebody's act with the benefit of hindsight. The trustee didn't have the benefit of hindsight when he took that act. And furthermore, even if the case was going to be stayed in 2018 and he knew it, in 2017, he still had response deadlines that he had to carry out. So we think the court erred there as well in finding that the notice was unreasonable for a host of reasons, those included.
Thank you, sir. You saved some time for rebuttal. Mr. Chappell, Chappell?
Chappell, Your Honor.
Mr. Chappell, good to have you with us.
It's good to be with you. It's an honor to be here. Thomas Chappell, representing Miley, and the name sounds similar, so they're confusing. Miley, M-A-I-L-E, Hardcastle, and we're the appellees in this case.
Are they twins?
They are not. They are half-sisters, Your Honor. I want to start off with something the court focused on early in Mr. Ohana's discussion. Mary Lee is not a party to this suit. They are not a party whatsoever. They tried to intervene, I believe it was in 2018. They were denied the ability to intervene. Judge Jackson ruled that the interest of the trustee, Mr. Midget, who is the actual opposing party to Miley in this case, who is not appealing, by the way, he ruled that Mr. Midget represented Mary Lee's interest in litigation. Mary Lee did not appeal that, didn't move to reconsider. So here we are years later. COVID happens, all that happens. Finally, we get to a ruling several years later, and the only parties before the court at the summary judgment hearing were Mr. Midget, who was representing Mary Lee's interest, and Miley. We litigated it. We had an adversarial hearing. The court ended up ruling that Miley had additional time to opt back in to the CRAT and to restore the CRAT back to how it was intended by its settlors, Captain and Mrs. Hardcastle. So the egg is put back together by Judge Jackson. So now what we have is a non-party seeking to intervene on appeal. So she filed a motion to intervene in the district court. There's been no ruling on that motion whatsoever. It's an interlocutory appeal. There's been no ruling on the motion to intervene. There was a notice of interlocutory appeal filed, so that put the pause on everything in the district court. So again, there's been no ruling on the motion to intervene, and she's trying to appear in this court while not being a party. And the case law is very clear on.
You want us to throw it out?
Yes, Your Honor. I moved to dismiss
in the
the case.
vernacular, you want it thrown out for two reasons.
That's correct, Your Honor.
Or alternative reasons.
That's correct, Your Honor.
Dismissal for lack of jurisdiction or lack of standing, or dismissal for lack of standing.
That's correct, Your Honor. So
which order do you put those in?
I think the most obvious answer is she's not a party. That's the easiest answer here. And there's a Supreme Court case, and it's a short case, but the point of that, it's Marino. It's from the 80s. Marino, and I forget the other party's name, but I believe it was from the late 80s. And in that case, there were parties, non-parties that tried to intervene, that were not parties at the district court level, but tried to intervene at the Second Circuit. The Second Circuit let them in because they had an interest in the suit. The U.S. Supreme Court said, no, you can't litigate a case, you can't appeal if you weren't a party to the proceedings below. And that makes sense when you think about it, because
Makes a lot of sense.
Because, I mean, how can you preserve arguments below when you're not a party? The court below is again, it's adversarial. The court below has the parties before it. And as we've seen in this case, at the hearing, there were certain statements made by Mr. Midget that we believe that led to the courts ended up ruling on the injunction, on the alleged injunctive piece. So there's a reason for not allowing non-parties to appeal, to intervene, I guess, for the first time on appeal. So there's some limited case law. Respectfully to this court, I would submit that case law it could be argued that even allowing any exceptions whatsoever to the Marino rule is potentially improper. But nevertheless, even under the rulings by this court, and I believe the Kinney case is one of them, the Doe case Mr. Ohana mentioned, and there's another case, Sky Center, that I cited in my brief. There are the reasons when the times in which someone who is a non-party can intervene, I put that in air quotes, for the first time on appeal, are when that party played a role in the very proceedings that are the discrete proceedings that are being appealed from below. So in all of those cases, the party that was seeking to, the non-party that was seeking to intervene on appeal had filed briefing in the hearing, had been involved in the hearings, that actually led to the ruling that it was being appealed. Mr. Ohana was not at the motion to summary judgment hearing. He didn't file a briefing in the case. And when I say Mr. Rohan, I mean his client, Mary Lee Hardcastle. The last time Mary
I mean,
Lee
there are these set of cases where the Supreme Court and this court have allowed non-parties to appeal in the government context, right? So one government entity litigates but decides not to appeal, and the Supreme Court suggested, in the recent Kentucky case, has allowed, in that case, I believe it's the Kentucky Attorney General, to then appeal despite having not been a party below. Do we take those cases to suggest this sort of Marino line is perhaps not as clean as you might read? I mean, Marino's pretty brief, but we sort of got to read it in light of some of these later cases that have permitted non-parties to appeal, in certain circumstances, right? And maybe those circumstances are different or similar given the context that we've got here. I mean, the Attorney General versus somebody else in Kentucky, and you got a trustee and a beneficiary. I mean, there is some, privity there that suggests to us these aren't like a total third party. I mean, I get it is technically a third party, but it's not quite so far given the relationship between, I want to say Ms. Hardcastle, but that doesn't help us, Mary Lee and the trustee.
Your Honor, I am familiar, not in great detail with I believe it's the Cameron case, the Kentucky case out of Kentucky. I think Daniel Cameron, the AG of Kentucky, was the appellant. I believe the ruling in that case had to do with, because it involved significant constitutional concerns, and I believe there were some other aspects of it that involved the fact there was a new person in office that had taken the AG's office. I'm not over, and I apologize if I'm...
No, that's fine. But my point is not, you don't fall under Cameron, right? I'm not arguing that Cameron is the controlling rule. My point is that part of what seems to animate Cameron is this idea that you've got sort of parties in privity, right? Not the word, but there's both part of the government. Here you got a trustee and a beneficiary. They're both part of the story. And so to call them true third parties is not really fair when we think about like the Marino line, where, as my recollection is, it was a true third party, not someone in privity.
Your Honor, I would submit that the ruling in Cameron is a very minor exception, that it should be limited to the circumstance which existed in Cameron, which was a significant constitutional question in which the AG had to appear.
It was a unique situation?
Yes, Your Honor. I think the Marino case law is very clear, and to the extent there's any gloss put on that by this court, I don't think Mary Lee falls into that box. I think that we had two parties before the court, one of which represented Mary Lee's interest, and Mr. Midget, the trustee, and the court held that it was not appealed. So I don't think she can appeal. I think that the only party that can appeal is Mr. Midget. And I will point out that the Marino case law lit the path for Mary Lee. Again, this case is still in district court. There's no final order here. And as the court, I heard discussion earlier about not wanting a piecemeal appeal. We don't know what the court's going to do with Mary Lee's motion to intervene. And the Marino case said that the right way for a non-party to try to appeal is to move to intervene. The court denies that.
Let me go back and ask you again. Is it lack of jurisdiction, appellate jurisdiction, or a lack of appellate standing?
It's both, Your Honor.
Well, put them in order for me. Which one do you say is the best argument for you?
Your Honor, I think they're both really good arguments. But
Pardon?
I think they're both really good arguments.
Yeah,
but
he asked for the best one.
the best
You can only
one,
have one best.
It's hard to pick my favorite one, but I think that
You have children?
I have one, so that makes
All right, so you actually have a favorite child, right? All right, so never mind. Yeah, you got one best child. Anyway, I was going to put you on the spot to ask which one was your best.
It seems like that hypothetical where, but yes, I think that she's not able to be here. She's not a party, can't appeal. And second, I think the fact this is interlocutory appeal of a purported injunction.
Well, she can't appeal that statement you made. Sounds like you're arguing standing.
I am, Your Honor, and that's argument one. That's why she can't be here. And I filed a motion to dismiss very early in the proceedings, hoping to get this case dismissed early. And of course,
You didn't want to come up here and see us.
It's not.
You don't like Judge King?
But Your Honor, respectfully, this appeal was.
You thought you'd draw a bad panel.
I'm sorry.
You were afraid you'd get a bad panel.
And clearly those fears were unfounded, Your Honor. But just to be clear about what this piecemeal appeal has done, it's put the brakes on the proceedings below. So the district court's order,
So they have stopped completely?
that's correct, Your Honor, and the court has entered a stay of the motion to intervene filed by Mr. Ohana. Again, it's put the brakes on getting to this ruling to a final order. So we have an order entered by Judge Jackson on August 10th, 2021. So that's, we're coming up on a year and a half of that since then. So in a year and a half, we've been in this interlocutory appeal. The district court case can't get to a finale. I think we're pretty close to a finale in district court procedurally, but because for whatever reason Mary Lee decided to interlocutory appeal, we don't have before us all the facts. We're limited in what we can cross appeal. It's not appropriate to have it in front of this court. And I also want to point out the point of having an interlocutory appeal for injunctions is to prevent or make something happen because it has to happen quickly. We can't wait till a final order. The general rule is a final order, but we have a limited exception only for injunctions, and that exception exists to prevent something from happening.
There are a few things other than injunctions, but that's one.
You're right, I misspoke, Your Honor. But in this case, the injunction is my point is that he can only appeal the injunctive piece of judgment.
But we have to have jurisdiction.
That's correct.
We're a court of limited jurisdiction. And first and foremost, we have jurisdiction over final decisions of the district courts under 1291. So this 1292 stuff is exceptions.
I 100% agree with
a
that.
narrow exception.
100% agree with that, Your Honor.
But you won't say which one applies to you.
I'm sorry?
You won't tell us which one's the most applicable to you.
I think they both apply. I think there are separate and independent bases to dismiss the appeal.
Can you help me with the 1292 argument? You've sort of slipped into calling it an injunction. When I read it, it looks like an order. And your colleague says, well, any order that requires anybody to do anything is an injunction. And it seems like our case law disagrees with that, right? We call them writ of mandamus, right? Is not an injunction. It might have the effect of being an injunction, but it's not an injunction itself. Can you talk to me a little bit about whether this is an injunction itself, or whether under cases like Rahman, we ought to think about this as an order that may have the effect of being injunctive relief, but in those cases, we've got an additional irreparable consequences hurdle.
That's correct, Your Honor. And candidly, we've wrestled with whether it is actually an injunction or not. 'Cause the Judge Jackson's order certainly did not call it an injunction. We agree with that.
And your brief vacillates back and forth in that regard as well, doesn't it?
Then it reflects that's correct, Your Honor. It reflects our wrestling with this question as well. Frankly, candidly, reading in the treatises on federal appellate jurisdiction, federal appellate procedure, appellate courts around the country and district courts have wrestled with this question as well. It's a difficult
So what is it?
I think it has the effect of an injunction. I'm not sure it is an injunction. I think Judge Richardson's question is a good one. I'm not exactly sure how to characterize it, to be frank. We haven't contested the ability to be here on an interlocutory appeal on the basis that it is an injunction, but we have contested on the fact that, as Judge Richardson pointed out, the injunction, quote unquote, has already been carried out. Mr. Midget has, pursuant to Judge Jackson's order, he's issued the new notice. Miley opted in, and I would push back on Mr. Ohana's characterization, and I don't think there's any basis for it in the record, that we were trying to somehow get out of paying the tax liability. The fact that we opted in and are paying our share of the tax liability, I think, should show that. I'll get to that in a second, but the point is the injunction's been carried out. Mr. Ohana's client, to her credit, has returned the extra money that she received from the CRAT while this litigation was pending. We received that money. We have begun receiving the CRAT payments. So
is that in fact the relief that you were seeking at summary judgment?
Your Honor, we were seeking an order from the court that the notice and the amendment and that was improper and that the demand was otherwise, or that the lawsuit was otherwise unfounded, that there should be a ruling in our favor.
So to put you back in the position you're in right now,
Correct, Your Honor. We wanted to put the egg back together as it was intended by the beneficiary.
So the ruling wasn't sua sponte, it's what you asked for.
That's correct, Your Honor. We asked for the court, and again, we didn't, I guess if we want to get very technical about it, we did not ask for 30 days to opt back in and 30 days for Mr. Midget to issue a new notice. That's not exactly what we ordered or what we requested, but we certainly requested that we be given an opportunity we certainly requested that the status quo be restored, that was the general gist of our argument.
Without the parameters or the effect of the effective adjunctive relief and spelling out the steps in which to get you there. You didn't spell out the steps, but you ultimately said we want to be put back where we were before the notice came so we can make an election.
That's Your Honor, that's one of the arguments that we made, is that the 10-day notice period was improper. That at the end of the day, we wanted to be let back into this CRAT. That was the core of one of our arguments, and that was the discussion with the hearing with Mr. Midget and Judge Jackson, that we wanted to ultimately put the egg back together.
I'm not sure you satisfied Judge Richardson. I've jumped in a couple of times trying to take you down the
I'm
road.
happy to answer your questions. Judge Richardson, do you have any questions on that?
No, I mean, I guess I just follow up with Judge Dawson. You did ask for an other relief as identified by the court.
I believe that's the case, Your Honor. It's been a minute since I looked at but that's typically what's in there. And again, that was an important point and I'm sure the court's already checked it.
That was on the form?
I'm sorry?
That was on the form that you had out of the law book or something?
Typically in my prayers for relief, I put those in there. And again,
Prayer for relief.
this has been,
Standard prayer for relief.
and just to point out
Anything else we can get?
That's correct, Your Honor. And just to illustrate the point, we've been at the motions for summary judgment. The cross motions were filed in September of 2018. So it's been several years since I've written that, but I have reviewed it in preparation for today. But yes, the point is, at the end of the day, we were very clear in our briefing and in our argument before the district court that we wanted to be let back into the trust. That we thought it was an improper decision made by Mr. Midget to kick us out with only giving us 10 days to make a decision. And the court followed that and frankly followed what Mr. Midget said below, Mr. Midget's attorney said below, that the court has an equitable power to allow this kind of relief. We don't disagree with that. I believe agree with that on the record in the hearing. So again, Judge Jackson had two parties before it. One party is asking to be let back in. The other party is saying, well, Judge, I think you have the authority to let them back in. Of course, he couldn't go all the way and say you should let them back in, but he recognized the court had authority to do that. The court saw that open door, went through it. Again, it's adversarial process, two parties before it. If Mary Lee thinks that Mr. Midget didn't do a good job representing her or didn't follow his fiduciary duties in representing her interests, she's welcome to go pursue other remedies against him for breach of fiduciary duties. But I mentioned that in our brief. But at the end of the day, there was a ruling in 2018 that Mr. Midget represented Mary Lee's interest. That was unappealed, and that ruling was still active at the time of the motion for summary judgment. The point was still the same. The only basis for a change in the argument for a change in whether Mr. Midget represents Mary Lee's interest is the purported Mr. Midget's unwillingness to appeal, which I'll point out again, we're at interlocutory stage. We don't know what Mr. Midget's going to ultimately do because we don't know what relief the district court will ultimately enter at the end of the day. So I would just point out that the court had before it what it deemed to be either all parties or people representing all parties that were relevant to the proceedings, had a statement made by Mr. Midget's counsel that the court had authority to let us back in. That was consistent with, we agreed with that, and that was consistent with what we were requesting, that the court let us back in, and the court went through that door and entered an order letting us back in, and we've been let back in and been living with it since that time.
Thank you very much.
And just one more point I'd like to
Go
make,
ahead.
if you don't mind. There was a discussion again there's some discussion about whether we had more than, or whether that Miley was trying to get out of paying the taxes, and that was what motivated her decision in 2017 to not opt in, and that's just not accurate, and that's shown by the fact that we have opted in. in 2017, there was a discussion made by Mr. Midget. There was a letter sent talking about a potential amendment in the abstract. My client, Miley, was not represented at the time. So Miley's not an attorney. She's not someone that is going to know the ins and outs of tax law. It took Mr. Midget, who was himself, by all accounts, a well-experienced and well-respected practitioner in this area. It took him a while to figure this out as well. Miley said, pump the brakes, let me hire counsel and figure out what's going on. And then soon thereafter, Mr. Midget issued a notice giving, for the first time, showing actual amendment language and putting a demand saying you must make a decision that has hundreds of thousands, if not millions of dollars in financial implications in only 10 days. That was what Judge Jackson ruled on. We think that was correct. So for the reasons stated in my briefing and today's oral argument, I would respectfully ask that the court first dismiss the appeal by Mary Lee Hardcastle as a non-party, and because the court doesn't have a jurisdiction on the interlocutory appeal, because the injunction's already been carried out, or the alleged injunction's already been carried out, or alternatively affirm the district court's ruling. I thank the court for its time and its questions.
Thank you very much, sir. Mr. Ohana?
I want to start with the issue about whether this was a sua sponte decision by the district court. It was. Any other relief the court can grant kind of language doesn't change the fact that Miley was a defendant.
But why? So, I mean, we have this recent case from 2020, SAS Institute, where we affirmed a sua sponte injunction from a district court judge, right? Even if he wasn't in the room, I would still tell you, we have a ton of respect for district court judges and their ability to understand, what the appropriate remedy is for the violations that exist, right? And so I guess I'm having a little trouble understanding why, even if we take your argument that this is an injunction, but that aside, that why we think that a district court is precluded from sua sponte issuing this type of an order.
To be entitled to an injunction, you have to plead a claim for it, or at the very least, make a motion. There are certain showings that you have to make. You have to put on evidence and establish.
No, but what I'm saying is we've said you don't have to make a motion, right? Like this is we affirm sua sponte injunctions. They're not very common, to be totally fair, because most of the time the lawyers ask for what they need, right? But where a experienced trial judge looks at it and says, listen, the best way to solve this violation is to issue this order. That doesn't strike me as like a peculiar. Now, maybe he was wrong here, but the fact that he did it sua sponte doesn't seem to be a problem, does it?
I wish I were more familiar with the case you're referring to. I do know that this case involves a beneficiary that's out $1.3 million because of this sua sponte injunction. She had no opportunity to stand in front of him and put on.
Yeah, but no, well, she did have an opportunity, right? So she sought to intervene, and then she had the opportunity to appeal that and chose not to.
Sure, but it's one thing when there's actually a claim for injunctive relief pending, or when Miley actually has an affirmative claim before the court that you could possibly anticipate that there's going to an injunction is in the offing.
Seems like to me your motion to intervene anticipated just that.
Certainly didn't anticipate that there would be an injunction, especially when at the time. I may point out also, and I don't know this 100% for sure, but it may be at the time that we didn't know whether Miley's motion to amend her answer and add counterclaims would be added. So that may have also been on our mind at the time, but the denial of our motion to intervene came out in the exact same order on the exact same day as the denial of her motion to amend her counterclaim. So knowing that to amend her answer to add a counterclaim, knowing she couldn't assert a counterclaim informed our decision not to appeal the denial of our motion to intervene. We at that point wouldn't have known that there could be affirmative relief awarded to a defendant that had no claim for it, with her request to amend to add a counterclaim having been denied. As far as standing, there are numerous cases, as the court alluded to, and as we included in our briefs. One of the most interesting ones, and it's quite recent, it's 2017 from the 10th Circuit, is the, give me just a second. It's the Osage Wind, please. Yeah, the case was United States versus Osage Wind LLC, and that was a trust case that involved the district court had before it the trustee, but not the beneficiary. District court entered an injunction that was detrimental to the beneficiary. Beneficiary followed up with the trustee, found out on the very last day to note its appeal that the trustee would not be appealing. The beneficiary rushed off, just as we did, to file a motion to intervene in the district court. That, of course, didn't get answered because it was on the last day. We did ours not on the last day. We did ours 6 days after this August 10th order was entered. We moved to intervene. We filed it as an emergency motion. We took every step we possibly could. We called the court. We noticed that the motion was briefed and ready for hearing. We just didn't get a hearing. Day 30 comes along. We file our notice of appeal, which is exactly what the beneficiary did in United States versus Osage Wind LLC. That's 871 F3D 1078, 10th Circuit, 2017. The court there held that this beneficiary's interests had diverged with the trustees, just as Mary Lee's interest here has diverged with the trustee. The trustee, all he wants to do, doesn't make any difference to him where the benefit payments goes. All he wants to do is just do what he's supposed to do. My client makes $1.3 million worth of difference where the benefit payments go.
But shouldn't we wait for the district court to make that judgment or that decision that the interests are or have diverged, and therefore you should intervene? Why shouldn't we wait for that?
We would be too late to file our notice. In other words, we filed a motion to intervene at that point. The court didn't take us up, and we're on day 30. We're at the very last day we could file our notice of appeal, and we had no choice but to file the notice of appeal. We could not wait, or we would have lost the opportunity to file this appeal.
Your position, this order, when there is a final judgment, you think this order will be non-appealable?
We're concerned about that, correct?
All right, concerned about it, I get, but do you think that it will actually be non-appealable?
I mean, I'd prefer not to commit one way or the other. If we lose here, I'd like the opportunity to try that, but I do think that it's on summary judgment, and there are holdings that were issued on summary judgment. I don't think that there's going to be a trial on these issues about whether the trustee acted reasonably.
So from your perspective, to answer Judge King's, the opposite of Judge King's question to your colleague, you would prefer that we rule that you could not appeal this order because that would ensure that you could later appeal it, as opposed to just saying you lack standing. Your preference is the 1290. If you're going to lose, you'd rather lose on 1292 than you would on standing.
Prefer not to lose, but
No, I understand that, but you're like your favorite way to lose is 1292. Okay.
Is that your answer? You agree with Judge
that is correct, yes. So for the reasons that we set out in the brief and here, we respectfully request that this court reverse the August 10th, 2021 order of the district court granting the injunction and order the trustee to countermand the second chance notice and for Miley to return the payments she's received since the second chance notice.
Thank you very much. We appreciate the arguments of counsel, and we'll come down and greet counsel and tell you that personally, and then we will, unless one of my colleagues advises me otherwise, we'll proceed to the next case. Spectators may be seated. We'll wait for the lawyers. Take your time. Mr. Arana, no problem. Our next case is number 21, 1947. Barbara Smith versus the Commissioners of St. Mary's County, Maryland, and others. Mr. Gagliardo,
Good morning, Your Honor.
good to have you with us, sir.
Thank you, Your Honor. Good to be here. I have with me at the council table today Gary Gilbert, and Ms. Smith and her son are present in the courtroom.
Very good.
I'm here, of course, to represent Ms. Smith. This case raises significant questions about constitutionally protective due process rights, not only for Ms. Smith, but for public employees generally. The case was dismissed by the district court for failure to state a claim, and in doing so, the district court largely adopted the reasoning of Egan versus Navy, which comes from the Supreme Court, and Jamil versus Secretary, which comes from this circuit. As I will explain momentarily, that is the incorrect law. It is factually distinguishable in many very significant ways. This case really is better guided by Green versus McElroy from the Supreme Court. And again, I'll come back to that in a minute and explain why we take that position. So very briefly, the pertinent facts are that Ms. Smith was a loyal employee of the St. Mary's County State's Attorney's Office, who was told in July of 2019 that she was suspected of leaking confidential information that was contained in a database referred to as OptiView. OptiView is a computer database. It is a system used by the Sheriff's Office in St. Mary's County, the State's Attorney's Office in the county, as well as the District Court of Maryland and the Circuit Court for the county. There is no evidence, and this is critical, there is no evidence to support the District Court's conclusion or the assertion by the appellees that the sheriff had the right to ban or to revoke access by an employee outside of his own office, in this case, the state's attorney's office. There's no reference to any statute, any regulation, any policy. But in fact, what the sheriff did was prior to Ms. Smith being...
Do you think there has to be a regulation or policy? So imagine Ms. Smith, instead of revealing confidential information, imagine that she went into the sheriff's office and stole a briefcase. Would that be different? So in other words, why does it matter whether there's a policy that says, if you reveal confidential law enforcement information, you will be fired, right? That seems like sort of the thing that says, there might not be a policy that says if you steal things, you will be fired. But we all know if you steal from somebody, that's likely to have consequences if it's related to your job, right? And so if you reveal confidential law enforcement information, it doesn't seem like we need a policy to say that, when you work in the law enforcement field, that's likely to get you fired.
Understood, Judge Richardson. Here's the first distinction. It's not the sheriff's call to hire, fire, discipline somebody outside.
No, totally fair, right? But that's my point, right? So she goes she works in the county attorney's office. She goes to the sheriff's office and she steals something, right? It seems like to me there doesn't need to be a policy for the county attorney to say, we're going to fire the thief, right? I mean, that doesn't strike me as necessary to have that written down in paper.
The issue is, did the state's attorney have a reason to fire her? She obtained her authority to access the system from the state's attorney, not from the sheriff. If anybody could revoke...
But he can't... So you're saying that... This is what I'm having trouble with, right? So your suggestion is the county attorney...
State's attorney.
The state's attorney, I'm sorry. The state's attorney learns from the sheriff that she's a thief, right? My hypothetical, right? I know this isn't about theft, but...
I understand.
Right? The sheriff says she came in, she stole whatever it is, widgets. That the county attorney can't fire her unless there's a policy that says we can fire thieves?
No. What I'm saying is that the state's attorney can't fire her unless he honors her due process, constitutionally guaranteed due process rights. And the issue in this case is...
I know, but you were asking, you said this can't happen because there's no policy, right? I'm just literally trying to understand your argument, right? You said there's no policy, right? And what I'm trying to get at is, why does that matter? Why is that either part of due process or otherwise, that you can fire a thief or you can fire someone who's giving away law enforcement information?
Let me clarify one thing. She is suspended under suspicion of leaking information. She is fired for merely accessing the database, which her immediate supervisor, an assistant state's attorney, says it happens, and when it does...
It's a confidential database.
It's a confidential database.
Is it, did it have a security classification like
No,
secret or top secret or?
No, Your Honor.
It's recognized as confidential.
right. No,
It's law enforcement information.
it is law enforcement information.
It's criminal, it's information relating to what?
Three different things. Investigation by the sheriff,
It's pretty important stuff.
investigation by the, I had my cell phone because there's something on there I want to read to you at the court.
Well, you won't be,
My
you're not the first one to have that happen
My
in court.
sincere apologies, Judge. It's not something that should happen. Three kinds of information. One are the investigation and police procedures from the sheriff's department. The second are prosecutorial documents, charging papers, and so forth, motions, whatever happens in the criminal procedure, either before the district court or the circuit court. And then, of course, there are the court documents, which are the disposition of the...
Does it include grand jury information, for example?
I honestly don't know if it does or not. I honestly don't know. I honestly don't know. But I want to clarify
But it's
one thing.
considered confidential. You agree with that?
Yes, I do.
All right?
But what I want to...
And she accessed it and wasn't authorized to.
She denied that she accessed...
She accessed it and she wasn't entitled to. This is a 12B6, don't they have to?
Correct.
We have to take the complaints true.
If she accessed it, it was without authority. She denies having accessed. Her immediate supervisor, the assistant state's attorney, says this happens. Her words, not mine. It's not a big deal. The reason, Judge Richardson, that I was talking about policy and statutes is because the district court said that it was the sheriff's, implied the sheriff was the sole authority to determine access or denial of access. It's not so. Let me quickly move to Egan and Jamil, because here are the significant differences.
Egan is the Supreme Court case.
Yes, sir, it is. So in those cases, first of all, Egan was a question of the jurisdiction of the Merit Systems Protection Board. Egan was fired because his security clearance had been revoked, but he had an opportunity and a right to appeal the revocation by a separate process. So too Jamil. Not so Ms. Smith. There was no alternative process. And that really gets to the heart of the matter.
Is that your allegation in your complaint? And I'm talking about the allegation as it relates to the sheriff. I understand the allegations as to the other entities within the county and our state. But where in your complaint do you allege that the problem is there was no right to appeal or challenge the decision of the sheriff to deny access to OptiView? Because that's the question as it relates to the sheriff, isn't it?
It is.
You say there are no rules, regulations, or statutes providing him authority, and he's without authority to permit or revoke employees of the state attorney's office to access OptiView.
Right.
And your challenge is there is no rule, therefore there's a violation.
What I'm saying is that the sheriff's decision to revoke Ms. Smith's access tainted the entire process from that point forward. He revoked her access in August. She wasn't fired until October.
So then what is your claim against the sheriff if you're saying it's his conduct that tainted other processes, but you've sued the sheriff as if he has done something wrong? I'm trying to understand what's the property interest that she has in access to confidential information or sensitive information? Because this court has said there is no right property interest in access to sensitive information. Where do you say you have that?
Ms. Smith clearly has a property right to the job.
All right, but I'm not asking you about the job. I'm asking about OptiView and access to the information.
Right.
Where's that allegation? Because remember, this is a 12B6 motion. Where do you say in the complaint where she alleges she has a property interest or a property right in access to the information?
Let me give you an analogy.
And I want to know where you say it in the complaint, because the problem is I'm supposed to be evaluating this case on what you said in the complaint.
In the complaint, we said she did not have a meaningful opportunity post-termination to challenge the sheriff's decision. That revolves around both whether or not he had any authority to intervene in the actions of the.
But don't you have to tell me first that there is a property interest that she has?
It's a condition of employment. It's the same thing as having a driver's license or admission to the bar as a condition of employment. You may not have a constitutional right to a driver's license, but if it's a condition of your employment, you have the right to notice and an opportunity to fix the ostensible failure to have or maintain a driver's license or bar admission or whatever it might be. You cannot, they're so inextricably linked that you cannot separate out the access from the right to the job.
So that justifies why she's suing her employer.
Correct.
Completely understand, and I know you're going to get to that. I'm trying to figure out then how does she sue the sheriff, because the sheriff didn't fire her.
The only thing we asked, the only relief we asked for the sheriff, and we amended it, to be solely an injunction to prevent him from interfering with the employment process, which was outside of its purview. So we're not seeking any other relief from the sheriff other than to keep.
That's effectively telling him that he has to grant her, right, to take the person who's like giving away law enforcement information. Sheriff, you must give her access to the confidential database, right? Which means the only way you can do that is if she has some property interest in, effectively confidential information.
Judge Richardson, she didn't give any information to anybody. The sheriff's own investigation concluded that. The culprit, so to speak, the culpable party probably is a better way to put it. The culpable party was a woman by the name of Donna Rustin who worked for the sheriff's department. Her son, Nick Rustin, was an associate of Alex Murphy, the criminal
But can't we
defendant.
agree, though, that the password was on the monitor and therefore others had access to it and therefore she didn't do a job, or she did not conceal it? So whether she gave it to someone, it was made available publicly, which is a violation of the policy.
She was found not culpable of that charge. The Grievance Review Board specifically found that that was not a violation. I think what...
So you're saying she didn't get reprimanded for having the password taped on the monitor?
No, she got reprimanded for not meeting at a designated time, which she said was the result of a death in the family. And the board said that she should have been reprimanded for that, exonerated her from the accusation of taping the password on the front of her computer, found her culpable of...
And so you're saying the
access.
sheriff can't say, I'm uncomfortable with that type of unfettered access because it was taped to a monitor, and therefore I don't want that individual to have access to confidential information. And you're saying that's a property right that she has?
Sheriff never said that, first of all. Secondly, what she has a right to is the job, and she has the right to be notified if there is a condition of her employment that's not being met. Pre-termination, she was not told that if she merely accessed the database, that was an offense for which she could be fired. What she had been told, and what she had every reason to believe, notwithstanding how the district court conflated a number of events to say, well, she really did know what was going on. She only knew that she was facing discharge because she was thought at some point in time, later found not to be true, of having provided Alex Murphy through Nick Rustin confidential information. In fact, the sheriff's own investigator says, I think she just looked at it out of curiosity. And her supervisor says, people do that, and it's not a big deal. And yet the grievance board says, we're going to fire you. Now, they claim they made an independent decision. That isn't so. I'm out of time, so I'm just going to say this in one sentence. If you look at the motion to dismiss by the county that resulted in the order from which we appeal.
It was an opinion that Judge Zenas wrote.
Yes, Your Honor.
Very thorough, very thorough,
It's a very thorough opinion.
very thorough.
But I think it's
And
premised.
she recites that your client had availed herself to every level of review, and spells it all out. Judge Zenas does.
She does, and she's applied the wrong law, and she's conflated incidents. The inferences are incorrect. She's ignored, as did the grievance board, the ample exculpatory evidence, including the conclusions of the sheriff's investigator, including the fact that they extrapolate from a series of unlikely events that Ms. Smith must have known the criminal identification number of the Murphy file, which was the only way she could get into it. I'll do this in one sentence. She would have to have known there was an incident that had occurred, that Murphy was involved, that charging papers had issued, that the charging papers had been delivered to a particular place, and that she would have gone to that place to get the criminal number so she could get into the system. There's no proof of any of those 5 elements. It's all conclusory, speculative. It's a case based on suspicion, maybes, could-bes, but not evidence. And she did not have a meaningful post-termination issue because the charge had changed from leaking to merely accessing, and because of the defects that I've just enumerated. This is very much akin to, in the criminal context.
Now, if you want to take some of your rebuttal time, you can do that, but you've used up your
I have.
argument time.
I'll stop, Your Honor. I just was going to mention Brady versus Maryland, and I'll do that in the rebuttal, sir. Thank you very much.
Thank you. Mr. Karpinski?
Good morning. May it please the court, Kevin Karpinski on behalf of the Board of County Commissioners for St. Mary's County. My colleague Carl Zacharias is here on behalf of the sheriff, and I'm going to focus my arguments on the claims against the county for pre-termination, post-termination, alleged violations of the 14th Amendment. But before I do that, the court had some questions about the OptiView database, which I'm sure Mr. Zacharias will touch upon. But this is unquestionably a confidential database. This has information, for example, the Murphy file that's at issue. This was an ongoing investigation, so to allow anyone to access it improperly would be totally inappropriate. And so that is what was sort of...
Can I just be, I want to make sure I understand what the facts are here. Are the facts clear that she accessed Murphy's file without a legitimate reason?
The facts are clear that the Murphy file was accessed using her password and her login credentials, and that the grievance review board, as well as the county, as well as the state's attorney and the sheriff, all concluded that it was Ms. Smith who did access that Murphy file.
And for our, I guess the rub I've got is, for our purposes, whether that's really true or not doesn't matter, does it? I mean, because we have like a due process question. Like, did she get enough process to determine whether that's right or not? We're not a like super review board to determine whether those determinations were correct or not, or that, you know, Ms. Ruskin or somebody else did it, right? That, you know, it was some other person, right? They concluded that, and the question only is like, did she have enough process to challenge that?
That's absolutely correct, Your Honor. This court's role, as well as the district court's role, was simply to determine whether there was adequate procedural due process under the 14th Amendment. Not
And
whether...
she got a specific notice. Judge Zenas spells it all out here and quotes the notice, right?
Yes, Your Honor.
And she says, Judge Zenas, that Smith availed herself to every level of review.
Yes.
Had an informal grievance, then she appealed to the GRB, and the GRB conducted a 2-day hearing, and they affirmed the termination with a nine-page letter decision. I mean, the process is spelled out there. Now, go ahead.
Well, yes, Your Honor, and I do agree. Judge Zenas' opinion is very detailed. There was obviously extensive pre-termination notice starting on the 15th, when they met with Ms. Smith, followed up with an investigation with Sergeant Merritt on the 29th, followed up with another meeting with the county on September 27, which ultimately culminated in her October 7, 2019 termination notice. So, as this court has pointed out, as the Supreme Court has pointed out, that pre-termination notice is just simply an initial check to make sure that there is not a wrongful termination. Ms. Smith clearly was on notice as to what the issue was, because at every turn, it all focused on whether she had accessed this Murphy file. So there clearly was adequate pre-termination notice, and as Judge King has pointed out, there was extensive post-termination notice. We had an informal hearing, a grievance in front of the state's attorney, followed by an informal hearing in front of the Director of Human Resources, followed by a 2-day hearing in front of the Grievance Review Board, where I think 12 people testified. There was evidence that was introduced. And then ultimately that was affirmed unanimously by the Board of County Commissioners. So there was extensive...
Do you think that much is required by the Due Process Clause? The Due Process Clause, in order to fire somebody, requires that many steps?
Absolutely not, actually. This is a case where this was due process plus. I mean, there were more steps in the process here than would be required to meet the minimum threshold of the 14th Amendment for procedural due process. And so there was obvious, the process was both extensive pre-termination and post-termination. I'm not going to belabor the point because I think Judge Dennis's opinion is very comprehensive. I'm certainly happy to answer any questions the panel may have if you have any, but unless you do, I will submit.
Thank you very much, sir. Let me see. Judge Dawson, you got anything else you want to add? Thank you very much. Thank you. Good to have you with us. Mr. Zacharias, and you represent the Sheriff of St. Mary County.
I represent the Sheriff of St. Mary's County Court.
What's the county seat of St. Mary's County?
County seat is Leonardtown or St. Mary's City. I think it's Leonardtown. Is it? What is it?
I thought
Yeah, it's Leonardtown.
Leonard.
Right the first time. I should have questioned myself.
It's southeast of southwest of Baltimore.
It's well south of Baltimore. You have to go
down towards Virginia somewhere.
Yeah,
okay.
It's a long drive. It's not too far from here, Your Honor. But the claims against the sheriff in this case, as we've already flushed out here, are for alleged due process violations in the sheriff's decision to revoke Ms. Smith's access to the sheriff's records of ongoing investigations through the OptiView database. The district court below correctly dismissed her claims under the Supreme Court's holding of Department of Navy versus Egan and its progeny in this court, because there is no recognized due process rights in a government employee's access to restricted, sensitive, confidential databases such as the OptiView database. The district court...
What's your argument? Your colleague says, all right, fine, but that rule doesn't apply if that somehow interferes with the employment situation. So you don't have a property right in the database or top secret clearance, but that if that's necessary for your job, that transforms it into something else. What's your response to that?
Your Honor, first, there's scarce legal authority to support that proposition.
Yeah, I acknowledge that, but why is it wrong?
And number two, it's just plain bad policy. Because if we're to adopt that as the rule, Your Honor, you're compelling the sheriff to leave open Ms. Smith's access or someone who is suspected of breaching confidential information in a restricted access database, and to require someone like the sheriff or someone in charge of national security or the FBI or something like that to maintain someone's access so that they can be afforded due process rights. That would potentially risk compromising national security, local law enforcement, and other public safety and security interests. And
that's sort of the point of Egan, is what you're saying.
Exactly the point of Egan, Your Honor, and its progeny is to say that what Egan very clearly said is that no government employee, there is no right to accesses for these types of confidential sources that are maintained by government agencies who are charged with keeping public safety and national security.
Is the sheriff charged with maintaining or owning that database?
I think it's a combination. So the sheriff is funded through the county, and the IT systems are provided through the county. And so the sheriff's records keeping, it's all maintained by county IT personnel, and I believe the record does reflect that. The county is maintaining the system, but
So does the sheriff regularly grant access and/or restrict access to that database?
the record doesn't reflect that, but what the record does reflect is that the database contains the records of the sheriff's ongoing criminal investigations.
Does that include confidential informants and things like that?
Exactly.
Grand jury information? Is that what
I
you're
don't know if
saying?
the record specifically spoke to grand jury information, but it's not a stretch.
Well, somebody mentioned something about prosecutorial material.
Yes, exactly. And I mean, imagine if the prosecutors also have access to it, presumably there is grand jury material and other things of that nature on there. And that's all the more reason why keeping access to this system very tight is very important. And in the event of a suspected breach, if the sheriff or the state's attorney or whoever has the ability needs to shut off that access, they have the
The state's attorney there is like the prosecuting attorney.
Correct, John.
There's one in each county.
Yes, there's a state's attorney in each county in Maryland.
There
It's
you
not
go.
a district attorney. It's a
I'm from
state.
West Virginia, we call them the prosecuting attorney. I think down in South Carolina, they may call them the solicitor.
And I know in New York, they call them district attorneys.
Yeah, the district attorneys, but the state's attorney here, the county attorney, we're not talking about the county attorney, we're talking about the state's attorney.
Not talking about the county attorney. Now, the county attorney, I believe, stepped in for the grievance proceeding, and that was the county attorney's involvement in this case.
But he's not the prosecutor.
He was the prosecutor for the grievance, for Miss Grievance.
He handled the grievance, but he's not the prosecutor of the crown, he doesn't write indictments.
Correct. Your Honor, I think the only argument that I think Ms. Smith makes in an effort to try to evade the barring effect of Egan is to sort of infantilize the sheriff into this idea that because he's only a local law enforcement agency, Egan and its progeny shouldn't apply because that only applies to federal officials who are charged with guarding national security interests. There's no legal support for that argument whatsoever, and quite frankly, the district court correctly agreed below with the sheriff that for all intents and purposes, the sheriff's interest in the OptiView database and the information contained in there was analogous to the federal government's interest in national security clearances. And then just to echo what Mr. Karpinski had already said, that the decision to revoke her access was not because the sheriff said that she in fact leaked the information to the suspect identified as Mr. Murphy. The sheriff's decision to revocate the access was based on the information that the breach came from her terminal under her credentials at a time when she was at work and there were no other potential suspects within her office that were identified. And that somehow, after that, she accessed that information. Mr. Murphy, who was the suspect in the investigation, did get that information. And under those circumstances, the sheriff was well within his discretion, as the Egan court describes, broad discretion, to revoke her access immediately and let her employer, the state's attorney, sort of deal with the fallout. And that's exactly what happened here. Your Honor,
Can I ask one question? You also raised as an alternative grounds for prevailing a sovereign immunity argument, and we've got some case law that suggests that you can insist upon a sovereign immunity ruling even if you were to prevail otherwise. Are you doing so here? I assume you're not insisting on such a ruling if you were to otherwise prevail.
Your Honor, we are not insisting. The law on that subject in Maryland is murky enough as it is, and quite frankly, I don't want to do anything.
I thought so. I just wanted to make that clear. Thank you.
So we'll rest on brief on that issue, the immunities issue, and the court only need to address it if it goes past the due process question. So unless there are any other questions from the court, we'd ask the court to affirm.
Thank you very much, sir.
Thank you.
Mr. Gagliardo?
Thank you, Your Honor. Just a couple of quick points. First of all, disclosing or failing to disclose exculpatory information, analogizing to Brady versus Maryland, realizing that liberty interests are treated or afforded more due process than property interests. But still, the failure to disclose and to properly consider exculpatory evidence, of which there, as I said previously, an abundant amount, is a violation of due process. I would ask the court, Judge Zinnes is a highly respected jurist. She did write a very thorough opinion. But the question is not how much did she write, but did she get it right? And so let me talk about Brady just a bit more. Brady involved national security. Those things can't be revealed except within the intelligence community under any circumstance.
Are you talking about Brady or Egan?
I'm sorry. Thank you, Judge. Egan.
Okay, so I just want to make sure I'm following the argument. Yeah, okay.
I appreciate the help. I can use all the help you're willing to give me. And so Egan's, the data that Egan was concerned about, similarly Jamil, are things that cannot be revealed outside of a certain circle. What about the stuff in OptiView?
Can I pause and just ask you a question? Because I didn't remember the Brady argument, going back to Brady. I didn't remember the Brady argument being made, and when I just search your briefs for the word Brady, I don't see it. Is that an argument that you made and that we have any authority to address? Was it made below? Was it made in your briefs? Or is it you just sort of throwing it in now?
We talked about exculpatory matters, I believe, in the brief. We did not, you're correct, we did not refer to Brady. I don't think we're precluded from raising new argument as opposed to raising new issues, excuse me, on appeal. Let me say something about, so anyhow, to close the circle, OptiView material, all the things we've discussed about, are discoverable. They're discoverable by criminal defendants in the course of the prosecution. That information has to be revealed. It is not analogous.
I'm sorry, can I just go back and make sure I'm following? Because I just looked through for exculpatory, and I don't see anywhere where you say they failed to turn over exculpatory evidence. There's reference to exculpatory information, right? You describe what you claim to be exculpatory, but I didn't see, and I admit, I'm a quick look, but can you tell me where in your brief you argue that there's a due process violation for the failure to disclose exculpatory information?
I think you're correct to say that it wasn't articulated as you've just phrased it. But I think
I was trying to articulate it as you raised it. That's what I'm trying to figure out. Have you actually made this argument?
And I'm just trying to be candid with you to say that we may not have raised it in the brief, but I don't think that's fatal to it.
There's a process by which a defendant would get exculpatory information,
Correct.
though.
Correct.
Not the process of going through surreptitious
Absolutely agreed.
third
Absolutely
party.
agreed. But I have to come, I'm sorry, Judge, I didn't mean to cut you off. If I can go back, pre-termination, she's told that what she is accused of is leaking. She is not told at any time, any of the meetings and proceedings that Mr. Karpinski referred to, is she told that mere access is a reason for termination of employment. And her supervisor says it's not. It's, quote, no big deal. Her words, not mine. There's so many things were conflated to assure that Ms. Smith would not remain employed. I'm not going to, anybody can guess what the motivation is, all right? We have a new state's attorney in St. Mary's County. It's not the state's attorney then. His deputy succeeded him in a contested election. That aside, talking about, as Mr. Karpinski said, the only proof was that a log showed that the IP address of the computer assigned to Ms. Smith accessed the database. That's analogizing it to a criminal case, the murder weapon. It was owned by Joe. Where's the proof that Joe used the murder weapon? There isn't any. So there's no proof that the IP address was used is not proof that Ms. Smith did anything. Secondly, the IT witness called by the county was questioned. Did you check to see if there was hacking or spoofing? He said no. Was there a forensic examination? Not by the county. Impossible to do by Ms. Smith. She was excluded from the premises and denied access to the system. All right? So this is a stacked deck, and based on supposition, maybes, and sort ofs and could be's, they say, well, she must have done it. That is why her due process rights were violated. The pre-termination notice didn't tell her mere access. The post-termination proceeding was clearly tainted by the sheriff's report. Here's what the county said in its motion to dismiss that resulted in the order from which we appealed. Although Smith claims that the GRB erred by failing to consider whether a lesser penalty would be appropriate, her argument is generally unpersuasive. Because the sheriff's office revoked Smith's access to OptiView, Smith would be unable to fulfill the duties associated with her position. Then he refers to the fact that Buffy Giddens, the assistant state's attorney, said that access was part of the job. Given that Smith's access had been revoked by the sheriff, and that OptiView access is generally a prerequisite for one to occupy her position, or any position within the state's attorney's office for that matter, the GRB could not have effectively fashioned a lesser penalty as Smith requested. If that's true, then they couldn't fashion a penalty, the ultimate penalty of discharge. Despite anything that the grievance board says or counsel argues, it is clear from this statement that the sheriff's revocation was controlling. It was not made known to Ms. Smith was told the sheriff had revoked her access pre-termination. She was not told when, why, or anything else. That is a violation of due process. Despite a very lengthy opinion, there are defects. Let me very briefly, since I didn't get a chance to mention it before, in Green versus McElroy, McElroy was fired because his security clearance had been pulled, but had been pulled by an agency that didn't have authority to pull it. Again, Judge
But is
Richardson,
it your
that's why I go
position
back to
that the
statute.
sheriff didn't have the authority to pull the access to the information?
There is no indication that he did. He never granted her access in the first place. He never monitored her activity or the activity of any other employee of the state's attorney's office. It only came up because Murphy himself, kind of unusually, Murphy himself tells the sheriff investigating, collecting a routine DNA sample. I got information. I got it from Nick Rustin. And then they start looking, they find a computer log and they say, oh, it's probably Smith. But the sheriff then investigates and says, oh, it's not Smith. She didn't give this to Rustin. She didn't give this to Murphy. She's exonerated of that. So let's switch up. Now let's say that mere access, not a big deal, but let's say that mere access is grounds to terminate. That's why this process was tainted, faulty, and failed to meet the requirements of due process.
Your red light's on there now.
Thank you. It's only 16 more seconds. I just ask that the court look carefully into the due process violations as I've articulated them and remand with instructions to reinstate the amended complaint.
Thank you, sir. We'll come down and greet counsel. You need a break? You need a break, sir. Number 221382, Jeffrey Israelet versus Enterprise Services. Mr. Zaslow, take your time there, but when you're ready.
Thank you, Your Honor.
Good to have you with us.
Thank you, Your Honor. Good to be here, and good morning, and may it please the court. Again, Levy Zaslow on behalf of the appellant Jeffrey Israelite. The issues in this case are, frankly, straightforward matters of statutory interpretation on our first issue. Mr. Israelite suffers from a disability in his right toe, significant mobility issues. He has issues walking, significant pain. At times he can barely walk, severely painful, and partial loss of use of the foot at times, even difficulty bathing himself. Most significantly, difficulty driving, particularly downtown driving, was a significant issue for him. The briefing is very extensive on the underlying facts, but I think it's critical to jump into whether or not compensatory damages and a jury demand are appropriate under an ADA retaliation case. Just weeks before trial, after a jury trial had been scheduled for almost a year, the defense moved to strike the jury demand. The basis for striking the jury demand rises and falls with the Seventh Circuit's decision, Kramer versus Bank of America Security. The Kramer case.
Well, it's not just the Seventh Circuit, right? The Ninth Circuit follows the same view. The Third Circuit follows the same view. And our court, in two unpublished cases that my good friend Judge King was on, also follows the same view. I mean, it's not. I mean, I understand you want to make it about one court, but in fact, it's every court of appeals to ever address the question, including our own, have found that compensatory damages are not available.
What I would say is every single one of those courts that have decided the issue rises and falls with Kramer. So respectfully, when this court initially decided...
As if they didn't make independent judgments about what the right answer was? I'm not sure I follow that, right? I mean, it seems like to me each of those decisions stands on its own, right? It may rely to some greater or lesser degree on a prior precedent, but each of those decisions in the Ninth Circuit, the Third Circuit, and at least two in the Fourth Circuit.
Two of them in 2004, a couple of months apart.
And those were directly on the heels of...
He probably actually remembers them. I had to look them up.
Yes, and Your Honor, the analysis in 2004 was compensatory damages in a jury trial are unavailable, see Kramer. That was the analysis that the court engaged in. So that's why the analysis in Kramer is really where you find the crux of both the Seventh Circuit and the Ninth Circuit analysis all arises out of Kramer. And what Kramer said was supposed statutory silence displays that there are no compensatory damages and jury demand available. What Kramer and the courts that followed it have left out is that a number of pieces. Number one, remedial statutes must be given a broad interpretation to the broadest extent appropriate for the remedy. And it also has to be read in the context of the structure and the provisions. And there is a direct textual link between the statutes providing for compensatory damages and jury demand in an ADA retaliation claim. The ADA clearly prohibits retaliation, as section 42 U.S.C. 12203A. There is no remedies within the retaliation provisions of the ADA itself. So in subsection C of 12-203C, it refers back to the rights and remedies that the remedies shall be those available under section 12-117. Shall be those in 12-117. 12-117 specifically says remedies shall be the powers in section 2000E5. Section 42 U.S.C. section 1981 specifically provides compensatory and punitive damages and by extension a jury demand under 12-117. So there's a direct statutory link providing that if there is a jury demand, there are compensatory damages available.
Well, but E5 says that in addition to the remedies authorized, you may get back pay, right? But the remedies authorized by 1981A include compensatory and punitive damages, but only for two classes of cases.
Well,
right? And so you just want to read that out to suggest that it applies to all classes of cases.
What I'm suggesting is what Section 1981A provided is that compensatory damages are available under Section 2000E5. Those shall be the remedies provided under the ADA retaliation. That's directly in the statute. That's directly in 12-117, which is that those shall be the remedies. So if those are the remedies within 2000E5, those shall be the remedies.
E5, the remedy that's actually available under E5 is back pay, right? So it says back pay. And also, the remedies authorized by 1981A. But the remedies authorized by 1981A are only for two classes of cases, not for retaliation cases, right? And so you just want to say, oh, since we're like 4 levels into the nesting doll, we should read out that exclusion. And so instead it should say, under E5, compensatory and punitive damages are available, period. But it doesn't say that.
What I'll say, Your Honor, is that Your Honor said that it is not an exclusion, Your Honor. In fact, Section 1981A actually has 2 exclusions, and it excludes disparate impact, it excludes good faith efforts. It actually has a list of exclusions. Congress did not exclude the ADA retaliation claims, which again move along with those same remedies in 2005. So Congress declined to exclude it. So the only question is, if 2000E5 moves, does the ADA retaliation move along with it? It's essentially, there is no remedy for A. A follows B. C moves B. Where does A move? A must move along with B. It has to be because that's a direct statutory link, and that's what the cases that have viewed it have indicated. In fact, this court has said that the Title VII remedies are applicable to ADA retaliation claims. The D.C. Circuit has likewise said that the Title VII retaliation claims are indistinguishable from those in Title VII. So it wouldn't make sense for Congress to say, well, go back and look at each step in the chain of where it's connected. Once the one moves, the other one moves along with it. And particularly given that both the ADA and Title VII are remedial statutes, and this court, again, has on numerous occasions indicated they're really indistinguishable, but because they're broad remedial statutes, they must be read for an expansive remedy. And once there is this textual link in there, it is appropriate to read the remedies along with it, because once B moves, A must move along with it.
What are we supposed to do with these earlier decisions? Just say they're wrong?
Well, this is the time for the court to engage in that statutory analysis. Those are pre-2007 opinions. They're unreported per curiam opinions, and it's time.
What happened in 2007? Why is 2007 relevant? I mean,
2004 is when our decision.
But why? What happened in 2007? Was there like a statute passed, or I know there's
There were
this
amendments.
ADAA? Is that what happened?
They changed the situation?
When they changed the Federal Rules of Appellate Procedure to allow citation to unpublished opinions. So these are, again, they were pre-2007 opinions where they really weren't even citable at that time. So again, I think you go look.
So it's not about. So it's not the ADAA. You don't think it's something about the statute. You think it's like the Rules of Appellate Procedure.
I just think when they're pre-2007.
They used to be you couldn't cite them,
couldn't even cite the
and
opinions.
now they're we can consider them for whatever weight
Now the court can consider that for
they're
whatever
entitled
weight
to.
the court deems appropriate.
And they're
Exactly.
not entitled to any weight.
And I would
That's
say,
what you say.
I would say that they're opinions of this court, and they are deserving of respect and consideration. And this court went back to Kramer's statutory silence provisions. So, and again, I would say, well, is it actually silent? And when we can look where the statutory links are, when one moves, the other moves along with it.
But your argument is, it is silent, but for your argument about how they move together. So you concede that it is silent. It does not specifically state it, but because of how you have connected them together, you're saying that's how that issue is addressed.
So the ADA retaliation claims are always silent on the remedies, because there is no remedy within the ADA retaliation provisions itself. So it always has to be connected to something else. It's always connected to the Title VII provisions.
Yeah, but you just had a discussion with Judge Richardson where you at least acknowledged that back pay is a remedy, and it is specifically identified in the statute.
Back pay is identified in the 2000, 42 U.S.C. Section 2000-5. It's specifically located within that statutory provision.
So there is a remedy specifically identified in the statute. What you're saying is because it's not the remedy that you're seeking isn't, we should then follow this analysis of A is following B in order to get to it. But what I'm simply asking you is you acknowledge that it is in fact not listed. It is silent.
It's not listed in the ADA, but what 12117 says is that it shall be the powers, remedies, and procedures within 2000E5. 2000E5 turns around Section 1981A specifically.
Well, 12117 is not limited to E5, right? It's got other provisions too. Our case happens to focus on E5, right? And E5 tells us that you can get back pay in addition to the remedies that are authorized by 1981A. But that only authorizes compensatory damages for two classes of cases. I mean, I don't understand how you can read authorized by 1981A as saying more than authorized by 1981A. I mean, it's like adding words to authorize, because, I mean, the language of 1981A does not authorize compensatory or punitive damages for retaliation.
What it does, it modifies 2000E5. It modifies 2000E5. And once 2000E5 is
No,
modified,
but E5 says, in addition to the remedies authorized by 1981A. And so we have to then turn and say, what is authorized by 1981A? And we go to 1981A, and it says compensatory and punitive damages for these two classes of cases, right? And so it's back to the question of, does that authorize compensatory damages for a third class of cases?
and
That's retaliation cases.
And I would say,
But the word is authorized, right? I mean, the question is, does that authorize compensatory damages? Like, if authorized is like an affirmative thing, right? So it's not just silence, it's a lack of authorization.
what I would say is that Section 1982A modifies Section 2005 and Section 12117. It actually modifies that statute. You have to read Section 1982A into 2005, which is exactly what that does, and that was the purpose of what it provided.
I'm sorry, say that again. So you agree that E5 doesn't get you there, but 12117 modifies E5? Help me understand that argument. Is that what you just said?
No, it's the link from 12203, which is the prohibition against retaliation, providing the remedy shall be in 12117. 12117 provides the remedy shall be what is located within 2000E5.
Okay, but you said that modifies E5. I heard you to say that modifies E5.
What?
And what I'm trying to understand is, how does that change the language authorized by 1981A? That's the rub, right? Because the language authorized, if it says that, I think you've got a problem. I think you're trying to say that 12117 modifies that language, but that's what I'm having a trouble understanding.
It's Section 1981A that modifies 2000E5, that modifies the remedies that are available within 2000E5, that expands that statute.
But
Taking some of the EEOC's time now.
Oh, sorry, yeah, I'm asking questions.
No,
Yes,
go ahead and finish your thought and answer his question.
just to conclude that point, is that once Section 1982A modifies 2000E5, that necessarily must modify 12117, which necessarily must modify 12203. It's a direct link when you go one to the next, and that's exactly what the Edwards court said, that's exactly what the Baker court said, that's what the case of all said, that once you modify this link, you've modified each one in the chain, and because it's not excluded, there are specific exclusions when there. This was not excluded within Section 1981, and as it indicated in the briefing, there were good reasons to exclude other pieces, and there's good reasons why, as we laid out in the briefing, as the EOC laid out in the briefing, why they did not need to include why they would not want to specifically reference the ADA, given the unintended consequences it would have. And there are obviously additional 3 issues, but I'd like to provide my time to the EOC.
That's my fault. I gave too much time to these lawyers in that first case, and they watched me, and they take advantage of me. I'm not going to punish the EEOC over it. Good to have you here, Mr. Driscoll McGeechan.
Very close. It's Driscoll McCackron, Your Honor.
McCaffrey. All right. I'm sorry.
Pleasure to be here, and may it
Okay,
please the court.
Good to have you with us, sir.
Thank you. We addressed 3 legal issues in our brief: the definition of disability, the adverse action standard for retaliation, and this damages issue for what damages are available for employment-based retaliation claims under the ADA. I'll start with damages, since that's what the panel has been discussing. And just to take a step back to state, the statutory path begins with the retaliation provision, where Congress chose not to provide separate damages for retaliation claims, but instead equate those damages to the damages available for employment discrimination claims. That's discrimination claims under Title I of the ADA. Congress then expanded those damages, as you discussed, in 1981A, where it added compensatory and punitive damages and a right to a jury trial for claims of intentional discrimination under the ADA. The references to 12112 and 12112B5. 12112 is the substantive discrimination prohibition section for the employment provision of the ADA. We can discuss what 12112B5 does, but really what Congress said is that intentional discrimination under the ADA is eligible for compensative and punitive damages. The way that it's structured, the retaliation and discrimination provisions links those two together, which makes sense given the incredibly close ties between prohibitions on retaliation and prohibitions on discrimination. The ADA's retaliation provision, after all, says that no person shall discriminate on the basis of protected activity listed in the statute. And the Supreme Court in Jackson, Gomez-Perez, and many other cases has said that retaliation is a form of intentional discrimination. Intentional discrimination in the workplace is exactly what Congress targeted with Section 1981A. We cited the statutory notes in our brief that discuss the importance and the findings and the purpose for providing damages for intentional discrimination in the workplace. Because that express link already existed between employment-based retaliation claims and employment discrimination claims in the ADA, there was not need for an additional reference to retaliation in Section 1981A.
So help me understand what the word authorized means then, right? So like, I think I follow you to this point, right? But when I read E5 and it says what, I'm looking at two things, back pay, right? And so back pay applies, right? Because there's no limit to back pay for this purpose in E5. But the other category is what is authorized by 1981A. And so I have to look at what is authorized by 1981A. And if 1981A was also without limitation, just like back pay, if it just said compensatory and punitive damages are available, great, we're done, right? It works. But when I read what's authorized by 1981A, I read those words, and that requires authorization, and it lacks authorization for retaliation claims. What am I missing there?
Well, Your Honor, what I'd say is, so 1981AA2 provides that claims brought under 12117, the powers and remedies provision for the employment discrimination section of the ADA, those compensating and punitive damages are available. And I'll say again that that's expressly what Congress linked the damages for employment-based retaliation claims to. I take Your Honor's point that you're addressing the fact that it then went on to say violations of the Rehabilitation Act and the ADA's employment provision. And that's where we think that express link matters, because we would not read that language in isolation. When Congress says for violations of Section 12112, it said, okay, these are the damages available for violations of that section. And it is elsewhere said that employment-based retaliation claims receive the damages that are given to employment discrimination claims under the ADA. One reason we can look at that is significant about the difference between retaliation and the employment discrimination claim explicitly referenced in 1981A is the retaliation provision stretches much more broadly than employment cases. It also involves retaliation involving public accommodations and public services. So if Congress had expressly referred to the 12203, the retaliation provision, it would have expanded damages for other kinds of discrimination as well that don't involve employment. But 1981A is focused on employment discrimination, and providing those damages for employment-based retaliation claims accomplishes exactly that purpose. I see my time is almost out, so I just want to say briefly, Appellee acknowledges that the district court relied on an outdated definition of disability from our pre-ADAAA regulations. Congress rejected that definition of the ADAAA, and our current regulation makes clear that an impairment need not significantly restrict a major life activity, but that's the standard that district court applied.
I want to talk to you about material adverse too, but
Yes, Your Honor.
before, can you just help me understand what is the difference between substantially limit and severely restrict? I mean, those seem like I get we cut things rather thin around here, but those seem like awfully the same thing.
I appreciate that, Your Honor. I think what is important in construing those two terms is the history of the application of that significantly or severely restrict standard in the Supreme Court's case in Toyota, and if I may continue.
Please.
That was a highly restrictive standard. So when Congress passed the ADAAA, it did it expressly.
I understand that they wanted to get rid of the prior cases, but we typically do that by changing the standard, right? And not just being yeah, you guys do it differently this time, right? I mean, this is the same words, but they want us to say something different. I just have a hard time understanding, realistically, how a lawyer or a judge or a juror would look at those words and think there's anything different between them.
I appreciate that, Your Honor. So Congress its express instruction, right, was the standard's lower. Our regulation at 29 CFR 1630.
The second one was intended to lower the standard, right?
Yes, Your Honor.
And would the court then, if there's a jury in a case like this, have to instruct the jury in that regard?
So what our
They
regulation...
just have to use the second one.
So so it's supposed to use the current standard, and our regulation standard we say is this isn't supposed to be magic words. You can compare the way that the plaintiff in the
And
case
Judge Gallagher,
conducts
we're
major
talking
life
about the
activities.
part of the opinion where she referred to the earlier standard rather than later standard too, right?
I'm not sure, Your Honor. I follow the question. I apologize.
Well, you say Judge Gallagher applied the wrong standard.
For the retaliation standard, she applied it in two standards. For the disability standard, I believe it was primarily in the one section. And so just to answer what I think the question is you compare it to the general population. So it's not a magic word standard. You say, how can they accomplish this major life activity or perform this major bodily function as compared to the general population? And Congress intended that to be a simple question to move the focus on to whether or not someone engaged in the act of discrimination rather than what it saw as a too stringent focus on whether or not someone had a disability before the age of AAA. If I may, I know you said you had questions on material.
I did. Here's the question about materially adverse, and I understand you take issue with the use of the word significant in layered. And I guess what I'm just having a little trouble with, right, is Burlington, as I read it, gives us three synonyms, effectively, right? And so they say, first, it has to be materially adverse, right? But that itself doesn't tell us a whole lot, right? So it goes on and says, well, what is that? That means dissuade a reasonable worker, right? Okay, well, now we understand that. But then it comes back and it says, we speak of material adversity, right? This is the first question, right? Because it separates significant from trivial, right? And so it seems like it's telling us three different things there, right? All of which it's treating as synonymous, right? Material adverse, right? Dissuade a reasonable worker, and significant. Those are all three parts of the same whole, right? 3 in 1, if you would. Why is that wrong?
Your Honor, I'm not sure that it's wrong. I just think they're different amplifications. So the standard isn't materially adverse, and critically, it set that out to distinguish from the pre-Burlington Northern cases, including the Von Gunten case from this circuit, that equated the adverse action for discrimination claims and retaliation claims.
Yeah, I get that on the employment piece, right? But it doesn't seem to be doing it with respect to significant versus trivial, right? Like that's the broad is we got to separate the significant from the trivial. How do we do that? It's got to be materially adverse. Well, what does that mean, right? That means that it has to, dissuade a reasonable worker, right? Why are those all three part of its chain?
I think where you get to is materially versus a standard, and then they give you the dissuade a reasonable worker standard, as this court recently recognized in Lauren Workman, that's the operating standard, that's a test the courts in this circuit and other circuits should apply to determine whether an act is sufficiently adverse for retaliation.
Well, but what the Burlington Northern does is that's the test we apply to determine whether it's significant or trivial. Right? That's the language that they use to separate the significant from trivial harms.
And I think one place where that may be causing concern is that I think the significant detriment test that the circuit applied and that pulled from that pre-Burlington Northern standard still incorporates that pre-Burlington equating of the discriminant and retaliation requiring the terms and conditions. So the word significant means not trivial in terms of Burlington Northern, but the significant detriment, as was used in the district court, and I look really primarily at the Adams decision, where the court laid out the significant detriment and how that pulls from Burlington Northern cases. And you see it in the district court here, where it laid out the significant detriment standard.
So again, this is sort of the same problem that we've got with disability, right? Is that the words are one thing, but you're worried about pulling from other case law, right? It's not so much that severely or significantly is different or significant versus trivial, but you're worried about the pre-case law, not the words that are being used themselves.
Well, I think the words carry the meanings that they've been given previously. So it's significantly or severely. Congress said that was too high. We need to lower the standard, and that's what our regulation currently does. Here, the Supreme Court in Burlington Northern changed the standard for retaliation claims. They don't need an effect on the terms and conditions of employment. And unlike in Adams, where it looked for a significant detriment to see if the conditions of the workplace had changed, the Supreme Court says it has to dissuade a reasonable worker. It has to be working that may well dissuade a reasonable worker. So the words are similar, but they really do carry different meanings.
But it's all, okay. I think I understand your position. Sorry about that, Judge King.
It's okay.
Thank you so much, and I appreciate the extra time. We appreciate your time and attention to these issues.
Good to have you here. Thank you for your help. Ms. Crow.
Good morning.
Good to have you, Ms. Crow.
Thank you. May it please the court, I'm Heather Crow with the Coleman Firm, and I'm I'm here today on behalf of Appellee Enterprise Services. It is our position that the orders of the district court should be affirmed. As you've seen throughout the briefing and the argument in this case, Mr. Israelite wants you to focus on his toe, but it's clear from the evidence that was adduced at trial that his employer, HP, focused on his performance instead. I do want to go ahead and get to a couple of the questions that came up in the previous discussion about, particularly with respect to the jury trial. First of all, there was some discussion about the Kramer case and this sort of what has been characterized as a line of cases that rise and fall. I think it's clear from those other cases, if you look at the Alvarado case, for example, it's clear that those cases engaged in their own statutory interpretation and analysis. And so while they came to the same conclusion, I don't know that they necessarily all rise and fall based on just one finding. And I think we have to assume that the courts have engaged in that sort of statutory interpretation in each of the holdings. As you mentioned, all of the appellate courts that have ruled on this have found that that statute does not, that the statute addressing retaliation doesn't provide anything in terms of damages other than equitable damages. One thing I wanted to comment on, the Kramer case does not rely on statutory silence. That wasn't what the finding of that court was. Instead, the court relied on a plain language reading and explained that it was very clear that, and I don't want to go into a ton of this stuff that was already talked about, but as 2000E provides for equitable damages, back pay in that sense is a form of equitable damage.
I don't mean to interrupt you, but maybe we want to start the clock.
Started, and it is counting down here, but it's not counting down on the monitor, so I've let IT know.
No worries.
You want me to just let you know in 5
Sure.
minutes? Okay.
Yeah.
Thank you.
It'll be fine.
Trying to get it to go. Not
Thank you.
Sorry.
No.
Sorry, thank you. 2000E provides very specific damages. It provides only for equitable remedies. What's important here is that when Congress, 1 year later, after the passage of the ADA Act, 1 year later, Congress passed the Civil Rights Act of 1991. They passed, that included 1981A. 1981A did set forth additional remedies only for specific causes of action, and it enumerated those. One of the things that was mentioned today was that, one of the arguments that was made was that because retaliation was not excluded from that, and there were a couple of things that were excluded, that that we should assume that retaliation could simply be read into that. That's wrong, and both context and statutory interpretation support that. First of all, there were two things that were excluded. One was disparate impact. Just for context, disparate impact was codified in the 1991 Civil Rights Act. So it kind of makes sense that it was not there, that it was excluded substantively as well. The title of 1981A is intentional discrimination. Disparate impact, by definition, is not intentional discrimination. So it makes sense that that was excluded. The other thing that was excluded were damages under 1981. And the notes, and I believe the memo of the sponsors in the legislative history show this, that the reason 1981 was excluded was to prevent duplication of damages between a Title VII plaintiff and a 1981 plaintiff. So it makes sense that those two things were excluded, and the fact that retaliation was not, is not dispositive and is essentially of no moment in looking at whether or not retaliation should be included. The other parties here have tried to indicate that retaliation is a form of discrimination, and therefore this sort of causal link has occurred. But the Supreme Court has been pretty clear, and this is some additional authority here, but the Supreme Court has been very clear that that's not the way that this particular statute should be analyzed. First of all, back in the National Railroad Passenger Corp case back in 1974, the Supreme Court cautioned that when legislation provides a particular remedy, the court should not expand the coverage of that statute to subsume other remedies. After that, the court ruled in the Nassar case, and the Nassar case was pretty important. It addressed some of the things that the Alvarado case also argued or also addressed, for example, the Gomez-Potter case. And what I mean is that those cases addressed whether or not retaliation could be read as a form of discrimination. And in the Nassar case, the Supreme Court said they can't under the Title VII context, and here's why. Those that had allowed that reading were the Birmingham case, that's the Jackson versus Birmingham case that's been cited, the Gomez-Perez case that's been cited. Those address Title IX. They address the federal aspect of ADEA. There were some cases that addressed 1981 and 82. The Nassar court separated those statutory schemes and said those were broad-based, broad language that didn't separately address retaliation and discrimination. And the Nassar court said that's different here because Title VII specifically provides for discrimination and retaliation separately. And where Congress has chosen to give us a very detailed statutory scheme, then we can't simply sweep them all together and assume Congress meant for them to be treated the same. And so under that analysis, which would control here as well, we can't simply assume that where both the ADA and Title VII are very specific, that they can just be all swept together or be part of a causal chain where Congress didn't say that. Congress has, the courts recently made a couple other rulings on that. One of them was the recent Badgerow case. And again, I don't believe the Badgerow case is in our brief, but it has some really good language in it. It was just passed this, it was just ruled on this past year. The Badgerow case looked at the FAA. Under the Federal Arbitration Act, the court said, well, if you look at Section 4, which allows a party to file a petition to compel arbitration, there's language in that section that allows you to look through and establish subject matter jurisdiction. Conversely, if you look at the other two sections that we're talking about, which were 9 and 10, which are vacator and confirmation of an arbitration award, the court said that same language is noticeably absent. And where there are pieces in one statute that say one thing, but that's noticeably absent in the other, we have to assume that Congress meant for that to be the case, that Congress didn't mean for them to have the same meaning, that Congress did what it said or meant what it said. I would also like to briefly talk about the ADA claims. This court, of course, has the authority and can affirm on any grounds supported by the record. We would argue here that, first of all, despite any language that was used by the district court quoting the pre-amendment language, that even under the correct standard, that Mr. Israelite didn't meet the disability standard. But even if he did,
You admit error on that point and say it's harmless? Is that what you're saying?
I would say that it's harmless for a couple of reasons. One is because...
Did you argue harmlessness in your brief? Or is this a latecomer
Well,
response to my question?
I don't believe that we argued harmless error in this context. We argued that, maybe not in so many words, but it didn't matter because he couldn't meet the other elements of his claim anyway. Whether or not he's disabled is only the first step in the prima facie case in the McDonnell-Douglas analysis. He couldn't meet any of the other elements as well, which the court found, that he couldn't show that he was meeting the job requirements. He couldn't show that there was any inference of discrimination.
Do we have a right to rule that he couldn't be disabled under any standard?
Yes, we would argue that you definitely do. We would argue that you do under the correct standard. And we do argue that in our brief. We cite a case out of the 10th Circuit that's right on that point where the court said, even if the court cited or relied on the old standard, as long as he doesn't meet it under the correct standard, we can still affirm the holding of the district court. And so it's our
Is that
position.
because we're reviewing this de novo? Is that your basis
That's
for how we're
correct.
able to ignore the error that you've conceded and look to other things with a blind eye to that error?
That's correct. That's correct. This is a de novo standard. The factual findings of the court below, however.
Isn't that I mean, don't we have a decision in Miller that does just that? It's unpublished as well, right? We've talked a little bit about unpublished cases today, but
Right.
we do precisely that in Miller, right? Where we say, might have used, I frankly can't tell the difference in these standards, right? Substantially limit or severely restrict seem to me to be the exact same. But regardless, the point being is that either one of those sets of words you want to pick, it wouldn't have made a difference here.
We would absolutely agree. That's absolutely our position, is that under the facts, and the finding of fact by the district court is a clear error standard. So applying the facts that were found by the district court to the law, he still couldn't meet the standard for having a
But the law,
limitation.
clear error applies to facts. And this is, you're not talking about a factual.
Correct. I'm only talking
You're talking
about
about a
the
legal
facts
error.
that the court found, the facts that the court found in making the ruling, in applying the law.
But if it applied to the wrong law, that's a legal error.
Correct, that would be a legal error. And so there's a de novo review for the issue of whether or not he's disabled under the statute.
Do you have a way to help me understand what the difference between substantially limit and severely restrict is?
Well,
I mean, I understand this sort of history that, they wanted to get rid of these old cases, but, if I'm a judge and I'm looking at those two words, happen to be a judge looking at those two words, but just hypothetically, if that was also true, help me understand how I see those as being materially different. I mean, we slice things thin, but that seems awfully thin.
Well, without going back into the history, as you said, you understand that. So I think applying it here, the new regulations state this, that we are looking at whether or not the impairment that the person has or alleges that they have substantially limits the ability of the individual to perform a major life activity as compared to the rest of the general population. And I think that language about the general population is probably the most illustrative of what we're looking for here. Here we have an individual who testified that he had, an impairment in his toe and that it, somehow affected his gait or his ambulation or whatever. But we also have testimony from him that he walks as his choice of exercise. He walks a couple of times a week. He walks up to 45 minutes at a time. And even if you take into consideration the occasional stop-start that he talked about, being able to walk for 45 minutes is not substantially limited when you look at the rest of the general population. He also talks about...
The point of the general population is to not compare him to a pro athlete, or what's the point of that? That's the idea. That's what you're getting at. That we're looking at sort of the general population. We're not looking at the most fit or the speed walkers aren't the right comparison.
Yes, I would absolutely agree with that. We're just looking at sort of an average Joe here. He also talked about having some pain in his toe when he drove.
Does he walk with a cane?
He did not. I can't speak to now. It's been several years. It's been almost 10 years since the relevant time period. But during the relevant time period, he testified he had no assistive devices, that he didn't need a handicapped room. He hadn't had treatment in years. And while, of course, none of those things are dispositive by themselves, altogether, they indicate that he didn't have any substantial limitation under any reading of the ADA. He talked about driving. He said he had some pain in his foot if he had to do stop-start driving. But he didn't give us, he didn't provide any evidence as to how that substantially limited. And in fact, he talked about one incident where he said he had some pain in his foot after he drove. Except that he also told us in his testimony that he was in stop-start traffic for 4 hours. So if we're looking at somebody that can drive...
What was he in for 4 hours?
His car, driving.
He was driving a car for 4 hours.
He was driving a car for 4 hours in stop-start traffic. So if you're driving for 4 hours in stop-start traffic, I'd venture to say that the general population might be uncomfortable after that. So if that's the kind of comparison that we're looking for, it's our position that he's not disabled under the ADAAA. And again, even if he was, he still can't meet the other requirements that he has to prove discrimination under the McDonnell-Douglas burden shifting analysis. As far as the Burlington standard that we talked about, that was talked about earlier today, it's our position that Burlington says it has to be a significant harm, not a trivial harm. The court used the phrase significant detrimental effects. It's our position that that is in complete conformance with what Burlington mandates, is that there has to be some sort of materially adverse harm. The Burlington court said that the anti-retaliation provision protects an individual not from all retaliation, but from retaliation that produces an injury or harm. And the things that have been alleged in this case, aside from the termination, the Burlington issue here is not talking about the termination. Aside from the termination, he hasn't alleged anything that was a significant harm to him. And
But
so,
doesn't he allege, though, that it's the culmination of things that led up to, in essence, being set up to be terminated by not going to various events, not having access to certain things that culminated into being able to create this deadline that he couldn't meet? Isn't that his argument?
that is his argument, and I'll say a couple of things on that. First of all, the two things that he really points to, which is his request for a hotel room, that he didn't, first of all, he didn't make that through his manager or through HR. He made that through the hotel. And his supervisor, Mr. Romas, was not the person who kept him from going to the conference. He didn't go to the conference because his registration was rejected after he and some other folks used a customer code. They were sort of bending the rules, and they used a customer code. HP Protect was a customer-facing activity. It was a customer-facing conference. It was not for employees. And so, you know, they wanted to go. They bent the rules. They used his code, and his got flagged when he called the hotel. Someone noticed it. The other thing that happened was he asked to be a driver on a rental car, but the reason that he didn't go to that was because Jess May, who was not his supervisor, she simply managed the budget, instructed him not to charge to her project anymore. And when that happened, he didn't have a need to go. Again, that wasn't Mr. Romas that did that, and there was never any evidence that Jess May was aware of the request at all. And as to your point, his sort of theory that he was set up, the evidence that was adduced in this case make very clear that Mr. Romas had been hired, and he testified to this extensively. He was hired to build a team. He was hired to build a team, an R&D team, and a lab. All of the folks that were working there were working under a general engineering code. Occasionally, they would go out to to another project. They would always come back to engineering or overhead. He explained that it was an investment that HP was making in order to develop these products and these architectures. But it is completely illogical for us to believe that Mr. Romas hired this person at a very high salary to fill a need that he had on his team. And then because he asked for a hotel at a conference that he didn't have to go to, and that didn't affect Mr. Romas or his budget in any way, he was going to pay for it himself, that had any effect on Mr. Romas, or that he bore some sort of animus against that, or that because he asked to be a driver at a meeting that Mr. Romas was not in charge of, and he didn't go to anyway, that those two benign requests would somehow, create this animus that would cause Mr. Romas to engage in a months-long scheme to set him up for termination. That's simply illogical, and the court found that was not what happened. The court found that he was discharged because he was a poor performer. And I'll also point out that the court relied on what it termed a, quote, mountain of evidence for that. There was, not only was there testimony, there was an extensive amount of documentation that supported her findings for that. And I think I'm out of time.
Very good.
We would ask that the court affirm the findings of the lower court. Thank you.
Thank you very much. We appreciate your help. Mr. Zaslow?
Initially, I would like to address the quote-unquote facts, as counsel just articulated, are not the facts that they must be construed under the procedural posture we're here today. All those quote-unquote facts were effectively a closing argument. The facts as displayed in our brief are how the facts must be construed given the procedural posture of the case. We're here on an appeal of dismissal on a case for summary judgment. The facts must be construed, like most people to us, as a non-moving party. And under that standard, number one, he's severely limited in his ability to walk. He cannot, I don't know what this 4 hours of traffic is. He could not drive downtown traffic. For his exercise, his big exercise is walking for 30 minutes in a Costco, quote, when he can. That is his big exercise, but at times he can barely walk. These are the facts that must be construed in favor of Mr. Israelite.
30 minutes, pretty good.
When he can, in a flat store like a Costco, we've never said he's always wheelchair bound, but under the case law, particularly under ADAAA, episodic impairments are clearly disabilities under the ADA. And in fact, the case
All the problems with the one toe. Everything emanated from a single toe problem.
It's from his toe problem that limits his ability to walk at times. It's severely painful all the time, and everything else as described in our papers. And
if we assume everything that you're saying is true, that then supports that he had a disability.
Yes, Your Honor.
How do we now get to somehow that disability was connected to the termination? That's what I'd like to hear you talk about. They say, well, he was not performing well. Where is the fact dispute with regard to not meeting a deadline and then being terminated for it?
And we had a powerful dispute of fact on this. In fact, frankly, we had a whole trial, and the trial was significantly divided on this issue. But ultimately, there's strong evidence in the record that Mr. Israelite was performing appropriately up until the time he made his accommodation request for HP Protect 2013. It was immediately after he made the request, that's when he was kicked off of all the daily meetings. That's when they stopped including him on the daily work. Once Mr. Israelite stopped complaining, it was quiet. Then October and November of 2013, that's when everything was good. That's when he started getting praised for his performance and everything else. In December, he turns around, he makes a second request for an accommodation. Then he's immediately met with swift retaliation. He's immediately met with not the interactive processes, of course, this court knows they must engage in, but he's met with an immediate response by Jess May, the manager, who's a manager. She's a high-level manager who has control over what projects people are working on, says, you are kicked off, you cannot bill to your only billable client. He was kicked off the one team building trip, including with roadmaps as entirely in the briefing, literally kicked off. The first day after they returned from the St. Augustine trip.
Did she fire him?
Mr. Romas fired him.
Right, not the woman you're talking about that said you can no longer bill to this client code didn't fire him, right?
It was Mr. Romas, but he was at the direction of Ms. May, who removed him from, so Mr. Romas removed him from all billable work at the direction of Ms. May. So Mr. Israelite goes to Mr. Romas requesting the accommodation to St. Augustine. Mr. Romas goes to Ms. May. The response is, you're off. And we know Ms. May was actually included on all of the HP Protect issues. So they knew this would happen. Frankly, the way it came out at trial, on the retaliation aspect of it was, here we go again, effectively. Here's Mr. Israelite bringing up his disability again. Here we go again, and it was immediately met with swift retaliation. And in fact, the trial, Mr. Romas made it even worse. He actually tightened the timeline even further to basically make it as immediately after Mr. Israelite requested the accommodation for St. Augustine, he immediately was removed from the billable work, and he started the termination proceedings. That was what he admitted in the trial, several weeks before he actually did it. So the way it came out at trial, it actually came, and we put this in our papers, it came even worse. Immediately after the request for the accommodation, he was immediately discriminated against and removed from all of the billable work. For all the reasons discussed in our papers, the facts here were sharply in dispute. It was the project that was given to him was a massive, impossible project with a severely tightened deadline that clearly would dissuade a reasonable worker from engaging in protected activity. For all the reasons stated, the facts in our brief, as well as the legal arguments in our brief, as well as the EOC, we request reversal and remand to the trial court. Unless the court has any additional questions, thank the court for its time.
Thank you, Mr. Zaslow. We appreciate it very much. And we appreciate all the council's presentations and their written submissions. And we will take the matter under advisement. And we will adjourn court for the day and come down and greet counsel. And and all the best to everybody.